Any mention?
Proceed. I beg to mention item number 22. Mr. Chandu is there in opposite.
Mr. Chanda?
Mr. Chandu is there. So already I talked to him yesterday.
Where's Mr. Chanda?
Mr. Chandu in Guwahati, he will not come today. I talked to him. So in this case, I supposed to take some instruction regarding the service of notice. So this is not completed. I didn't get any instructions. That's why I tell this.
Mr. Devnath, please phones allowed time to obtain instructions on the status of service. On respondent's number?
6 and 7.
6 and 7. I'm taking your word for it. I'm not doing it. Yes. Yes, after 2 weeks.
So you will see another item, this 25 and 26. I have taken concept. After 1 week.
Who's on the other side?
That is why I just talked to him.
Why you always matter repeatedly? 18 matter, 18, 19 matter. Why?
After a week.
Let's do it. Why?
Some difficulties there.
What difficulty is there?
Actually, you see this in the file, some problem I found.
You've lost the files?
Some is missing was there. So,
so what are we to do?
After a week.
Mr. Chakreso, you help him if he has any materials missing from his file.
If he lost, I can give him also. I hope next time he'll not trouble me. It's a pending case. All case.
No, this matter he's been adjourned repeatedly. We can't allow this.
Yes.
After a week.
After 1 week, we'll do it positively.
Yes.
1 week, yes.
Okay.
On the premise of that, as he needs to reconstruct his file. Yes.
Lordship, I beg to make a mention of item 31, Lordship.
31.
Lordship. Mr. S. Day is on sanction leave, Lordship.
Who?
Mr. S. Day is on sanction leave.
Kennedy Marak.
Lordship.
2 weeks of the Army Council on sanction leave. Yes.
Much pleased, Lordship.
Please, Lordship, I beg to mention item number 28 and 29. The conducting counsel is on sanction leave. I pray for 3 weeks' time.
3 weeks.
My lord, I appear in 29. In 29 IPM.
Alright.
Lordship, I beg to mention item number 33. Counsel Mr. P. Yobin is on sanction leave, Your Honor.
My lord, I pay for the MCA. My friend is for the state, I'm for the MCA.
2 weeks is on sanction leave. That's it.
Your Lordship, I beg to mention item 24 as learned DSGI is out of station.
24.
24, Your Lordship.
It's a contempt matter, my lord. It's a pending case.
You are there.
I'm there, my lord.
1 week is.
Your Lordship, and similar prayer for item 35 as well.
$35 2 weeks. 35. You have taken consent?
I filed the application.
Yes.
Supplementary list, item number 1.
RPI.
May please, Lordship.
Yes.
Lordship, this is election petition, my lord, filed against the respondents, my lord, more particularly respondent number 1, and because under the IT, yes, my lord. So, my lord, my main ground, my lord, which has been challenged, is appeared at prayer number 3.5, prayer number 11.
Which page?
Page number 11, prayer number 3.5.
Page number 11.
11, prayer number 3.5.
Yes.
Yes,
You kindly read.
yes, my lord. That it is pertinent to mention here that the respondent number 1 has willfully and deliberately concealed some material facts while filing Form 26 affidavit in connection with the recently completed general election of Legislative Assembly of the Meghalaya 2023 from 28 Sohara ST Assembly constituency. However, the same were disclosed earlier in Form 26 affidavit filed in connection with the general election to the Meghalaya Legislative Assembly 2018.
You see this discrepancy between what 18 and
18 years, which was disclosed in 18 because this was concealed in the 2008.
what would he fail to disclose?
Yes, my lord. I'm just reading for the my lord.
Yes.
The respondent 1 failed to disclose the following in his affidavit filed under Form 26 accompanying nomination in connection with the general election to the Meghalaya Legislative Assembly 23. That the affidavit filed under Form 26 accompanying the nomination paper in connection with the general election of the Legislative Assembly of Meghalaya 2023 before returning officer for election to the 28 Sohara ST Assembly constituency, respondent number 1 had failed to disclose his own active bank accounts such as Vijay Bank account bearing number so and so, Vijay Bank account bearing number so and so, Hindusland Bank saving account number so and so, and the Indian Bank saving account number so and so. In the movable assets column number 7A of part A at cell number 2, page number 7 of the Form 26 file on 3/2/2023, man. And the B, that the respondent 1 also failed to disclose movable assets in column number 7A of part A at cell number 6, page 8 of the Form 26 file on 3/2/23, inasmuch as he failed to disclose the following motor vehicles belongs to him: JCB 4DX bearing registration number so and so, truck full body.
Then come to C.
Yes, my lord. See that the serial number 2, column number 7B of the part A, page number so and so, file on so, detail of the immovable assets column, the respondent number head 1 had disclosed 4 properties as non-agricultural land, out of the which 2 are inherited, and properties in the 2 are self-acquired, and the cost of the land is at the time of purchase is mentioned as 60,30,800. However, he gave an annexure at page number 26 of the annexure 4 instead of annexure 6, and the cost of the land at the time of purchase is rupees 52,80,800, which is itself is wrong information by representing the same at wrong annexure, which amount to concealment of the material fact. In the said annexure, he also mentioned only for 2 non-agricultural lands as against 4 non-agricultural land mentioned in cell number 2, column number 7B of page part A, page number 10 of Form 26, file on so and so. D, the serial number 4 of column number 7B, part A, page number so and so, the respondent 1 has taken the reference of annexure 4 again for a detailed residential building. However, he had given the details of the residential building at Annexure 5 at page number 25 of the said Form 26 file on 3/2/23, which is completely mismatched and wrong information. Moreover, the respondent number 1 had declared that the residential building were inherited properties, and simultaneously he also mentioned that the same to be purchased by providing date of purchase. And after declaring the date of purchase, he disclosed the purchase value as nil at page number 13, thereby making his affidavit accompanying Form 26 false affidavit matter. And E, that the serial number 6, column number 7B of the part A, page number so detail of immovable assets column, the respondent number 1 had disclosed only rupees 55 lakhs rupees as total of current market value of serial number 1 to 5 of the said column 7B, whereas he disclosed rupees 2 crore 86 lakhs 2,917 only as the immovable asset value in the abstract column of the part B in column number 11.8, page number 19, by making a separate column which is wrong format of the affidavit itself provided by the competent authority, and moreover mismatch false with the information.
Just see the affidavit file in 2018 where it...
Yes, my lord. 2018 affidavit is my lord. Kindly come to my lord, page number 78.
Just show one discrepancy between 18 and...
Yes, my lord.
Yes.
Page 78, my lord.
Yes.
The bank accounts, my details. 7A. Bank accounts.
Yes, 7A description.
7A, because column number 2,
Yes.
7A description column, details of Visa bank account is given, and these bank accounts are given in Indus Bank also, because this has been completely concealed in the current affidavit.
Subsequent affidavit.
This is one of the main
Indus
grounds.
Bank, State Bank, Indian Bank, HDFC
Yes.
Bank. Now let's see the current affidavit.
Yes, current affidavit, my lord, kindly see.
Page.
Page, my lord. 48, my lord. 11 page, my lord. I am coming to page number. Page number 54. Column number 7A. And column number 2, my lord.
54.
Yes.
Yes.
69.
And my lord, kindly see, my lord,
69.
page 69 also. After this, my lord.
Come to 54 first. This is cash in hand.
Cash in hand, my
Bank
lord.
account, that's all.
Yes, my lord.
And show 1.
And Annexure
Page
1.
64.
Yes, my lord. Page 69. 69.
Yes. 69.
Yes, my lord.
It
Bank
is
account of
closed.
city.
Bank, HDFC Bank, State Bank, ICICI, Indus Bank is there.
But that particular account.
By particular account, my lord, which has been disclosed earlier, this has not been mentioned here. And whether if it is not to be mentioned, but what is the status of the bank account, whether it is closed or whether it is non-operative, whatever may be the cases, that has to be disclosed in the current affidavit. It is not done so, my lord. That is also one of the ground, my lord. And regarding page number 10, internal page number 57 and internal page 10 of the affidavit, and regarding the properties matter, regarding the properties of the non-agricultural land matter, column number 3 matter.
Yes.
Column number 3 matter.
Commercial buildings.
Column number 2,
Yes.
non-agricultural land. Number 1 is giving Maulai, Maura. Number 2, Umtil. Number 3, Langlibun, Maukiro. And number 4, Maukok, and there's something like that. Area is called so and so. And whether inherited property, yes or no, that he has only mentioned 1 and 2, Maulai and Umtil, and he never disclosed about the rest of the 2. Whether is it inherited or whether is it purchased, this has not been disclosed. And number 3, their of purchase is given again. And number 3, only number 3 has been this particular number 3 has been sold as purchase, and number 4,
1 and 2 left.
1 or 2 that has been left out, my lord.
And one more thing.
And another one, my lord.
Page 59.
Page 59, my lord, again. Regarding residential building, my lord.
Page?
Page number 59.
Okay.
59 of the same, affidavit.
Residential building.
A residential building including apartments location, my lord. And he has been mentioned, my lord, Annexure 4. Annexure 4, what has been mentioned, my lord, there are 2 Annexures 4, because this cannot be, my lord.
Annexure 4 mentioned, where is right?
Annexure 4 is available, page 72 also. 72. because these are the detail of the vehicles, my lord, instead of the
Court
property.
is examining whether,
Yes, yes, my lord.
because election matters, we have to see whether it is
Yes, yes,
family
yes.
issues,
That,
and
that
so-
needs to be examined, my lord,
Yes.
mandatory, my lord.
So whether we issue summons or not.
Yes, yes, my lord. Annexure 4, my lord, and CPS 72, my lord.
Yes.
Because name of the vehicle, these are the details of the vehicles, not a lane. But instead of giving lane, he has been mentioned all the vehicles, my
Whoever
lord.
advocate who appeared this affidavit has not been very mindful of the.
Yes, because that's
earlier
the
affidavit,
mistake.
yes.
But that is the only way, my lord, how election has to be declared null and void, my lord.
So your only challenge only with regard
Only
to
to the affidavits only, my lord.
that you say is false declaration,
Yes, yes,
suppression.
yes, my lord. That's all, my lord.
Yes,
This number 1019.
yes, sir. But Mr.
And Jatendra Senior Advocate.
Ranjit Singh for the petitioner, assisted by.
Murtaza, my lord. It's reflected in course list, my lord.
Said
Yes.
Said
Said
Murtaza Ahmed.
Murtaza
Give
Ahmed.
your name, yes.
Said Murtaza Ahmed. I will supply the name, my lord.
No,
Said
it's
with the
always
typical.
reflected in course list.
Issue notice took summons to the respondent. Up, you'll take steps.
By speed post, my lord. By speed
Yes,
post.
sir.
To all respondents.
Steps to be taken for issuance of summons and notice within 1 week.
Yes, ma'am.
Yes, just a matter again after 3 weeks to await appearance of the respondent. Well, election petition starts only when the respondent appears.
Yes, my lord.
Yes.
My lord,
So 3 weeks, you take a date.
my lord, can it be, my lord,
You take a date to the court master.
can it be on 12th, my lord? 12th. 12th, that is Friday because it falls.
Yes.
12th.
On 12.
Yes, ma'am. Oblige, ma'am.
Item number 2.
It's within time, correct?
Yes, within time. 12 is within time. That is after 3 weeks.
Item number 2.
What is this, Mr. Bora?
My lord, here in this case, it so happened that the petitioner and the respondent, they had entered into an agreement for sale of a property. And towards the advance, the respondent paid 50% of the price, 6 lakhs. And the remaining 6 lakhs were supposed to be paid by end of 2 months. They had an agreement to that effect. Now, the respondent failed to comply with the agreement. He defaulted, in a sense, within 2 months he could not pay the remaining 6 lakhs. And he asked for extension of time verbally, which was verbally granted. And it went on for about 10 years.
10 years.
Yes, nearly.
Because
the agreement was
for sale. The property is still with the petitioner.
Something has happened. That is why this.
What has been something has happened?
Now, the agreement was in 2010. Till
2010, you made an agreement.
Till 2000.
For agreement to.
Yes.
Yes, the respondent made an agreement with you to buy your property. Yes. Correct. Made an advance, and it.
He did not pay the remaining, so I have not handed over the land also to him.
What happened?
Then 2014, instead of going for resignment of the contract or cancelling of the contract,
Did they say that we will not to annul the agreement?
he didn't say anything. He didn't say anything that he is not going to buy the land. He secretly filed a money suit for the
what?
6 lakhs before the court of the CM as the additional subordinate district council court. Now my question, first of all, is that money suit does not lie in this case. He should have gone for resignment of the contract.
Contest the matter.
No.
Why?
It went ex parte because the petitioner did not get notice.
Is that a fact?
Yes, my lord. Then ex parte judgment, decree was passed ex parte in the money suit, and this decree was transferred
For how
to
much?
the
With interest.
with interest. The
When was the money suit?
decree has been.
When was the money suit filed?
It was filed on 2014. 2014. Money suit number 1 of 2014 before the CM of Milliam. And his judgment is Hukum Pinskan. Yes. On page
Anyway, we
24.
should notice.
Yes,
Very
ma'am.
peculiar kind of matter. heard Mr. P. Boran, counsel for the petitioner, issue notice. Service steps will be taken within 1 week by said AD upon the sole respondent. List thereafter, after 3 weeks. Yes, on.
Obliged.
Main list, item number 1.
My lord, this matter, it was taken up yesterday
What happened?
and post the matter today for hearing. So every matter may be taken up next week.
Here what has happened,
Tomorrow is the
Lordship,
holiday.
here what has happened, the matter was fixed on 9th December, then it was subsequently fixed on 27th 1 for...
No, we're not concerned with that, because the last order was that submissions were made that since the matter,
Yes.
injunction matters will be
Lordship.
heard on the 11th.
Lordship.
So that's why this court posted the matter on the 13th.
Lordship, yesterday what has happened, yesterday respondent number 2 has filed an application order challenging the maintainability. So that is fixed today for Lordship Swokos and hearing.
Then
Lordship.
this is
Then
matter
Malum
after
have
a week.
Monday Lordship.
After a week.
After a week, Lordship.
It's a matter of a week.
Much
As
of it.
hearings yet to conclude before the trial court.
Yes. Much.
Item number 2.
Wait, please, Lord.
Yes, Mr. Kumar.
Yes, my lord. This is the Lokayukta matter, my lord.
Yes.
The Lokayukta directed registration of FIR without following the procedure prescribed in the Act, my lord.
Yes.
So the case in the state is that the order passed by Learned Lokayukta is wholly without jurisdiction, my lord. And for that purposes, my lord, if I take your lord.
1 second, it's for what today?
Lordship, I had raised an issue of maintainability in as much as, according to me, the state doesn't have the locus to challenge the orders in question, my lord. So today is for Lordship to adjudicate on the issue of maintainability.
Today is on maintainability. Do we argue on...
I would like to place all the judgments on the maintainability issue, and also I would like to place relevant case laws, my lord, your lordship, because this will require some hearing, my lord. Because this is a very important question of law which has been raised by my learned friend, and it has got bearing in the other cases, whether any direction to the state which is divorced the law can be issued by the authority or not only by local but other authorities also. So it involves important question of law, my lord. So your lordship may have it. I will physically address this matter. Your lordship may have it after 2 weeks. My lord, I will address this on the report on this issue.
No further adjournments, but after that.
Yes, no further adjournment, my lord. I can argue today also. I'm ready, my lord.
But hybrid is a bit difficult if you want to shoot. Have you brought authorities? Have you
I have
been
brought the
compiled?
authorities, my lord. I have placed. I have prepared a compilation also.
Anyway, when you come physically, we'll hear it. Yes, as the matter is to be heard on the question of maintainability, you raised the question, when was by affidavit or by?
Through an affidavit, my lord. And against that affidavit, Lordship, this was filed on 6th April, my lord.
6 April 23.
22, last month. Last year.
22.
Yes, my lord. Against that, my lord, reply has also been filed.
Okay. Yes. Then we'll write that this way. Mr. A. Kumar prays that as the question of maintainability will, at the hearing, the question of maintainability will require some time. He prays that the same, and he's not available in the station. He prays that the same will be listed after 2 weeks. Yes, Mr.
In this case, I got this copy of it. It's you could given. So I need some instruction from.
What instructions do you need? The 29.3. Where's Mr. Abraham?
May I please, your lordship, let the matter. Your lordship, please to adjourn the matter today because.
Why? He's not well.
He's not well. He just informed me to take the file today morning, so I also could not prepare.
Have you received a copy of the report?
Yes, I have.
What do you say about the report?
The deputy said, elusive this private respondent, he is the Hindi teacher, he is not the social teacher, and my approval is there for the social science teacher. As for this.
What does the report say? What do you have to say in the report?
In the report, it is whatsoever he has given gist of it, and it is.
When will he come?
Next week, your lordship.
After a week, yes, due to absence of arguing counsel for the state. Yes. By the time we come with instructions.
Item number 4.
Yeah. Yes.
Please, Lordship. This was the matter where the Honorable Court had already found, my lord, in the previous order that the appointment was illegal.
Yes. Yes, Mr. Prasaji.
My lord, the government has already taken steps, my lord. If required, we are ready to file an affidavit.
Who's appearing for number 6?
I am.
So your appointment has been cancelled.
Yes.
You're Moon Akram.
Yes.
You file with your after.
Well,
1 second. Yes. So what remains now?
Lordship, it may be disposed of and fresh election may be called for.
You have anything to say?
yes, my lord. I have to say.
What do you have to say?
Challenge this.
Because how will you challenge this termination? It will be a different by an independent proceeding. As the things stand now, the court has found that you've been illegally appointed, and directions were issued to take corrective measures, and now they've cancelled your appointment.
Now I can say that it is not illegally appointed; it is legally appointed, and then all the higher authority also accepted. What is the term and condition? I have fulfilled all the criteria of NCT norms.
Yes. Pursuant to order dated 23/2/2023, the state respondents have issued an order dated 30th March 2023, whereby the appointment of respondent number 6 has been cancelled. Stop. A copy of the order dated 30th March 2023 has been produced by the learned GA, and it seems placed on record. So what do you have to say?
Lordship, in fact, as per the order itself, the direction is given to fill up the post by fresh recruitment.
Yes.
As per prescribed norms.
Yes. Next paragraph. Mr. S. Deb submits that as the appointment of the respondent number 6 has since been recalled and cancelled, and orders have been issued for directing that the post be filled up to fresh advertisement. Additional prescribed norms, this petition may be closed with direction respondents to expedite the recruitment process.
And consider the petitioner.
It would be the.
It may be fresh advertisement.
But that will have to be done by the managing committee, my lord.
Of course, by the who for managing committee?
But my lord, at present there is no managing committee, my lord.
Then the SDSCA will do it. Who's running the school? Under whose administration?
My lord, that administration for the moment is with the SDSA, my lord.
Then?
Now the question is whether he can issue the advertisement, my lord.
Why
because
not?
he is the approving authority, my lord. So firstly, my lord, the managing committee will have to be constituted, and thereafter the advertisement should be issued.
They have to take a call on that.
I would also pray, my lord, that in case since it will be a fresh advertisement, the petitioner, my lord, when in this initial advertisement, which has been now found to be illegal, my lord, at that point of time she was having the prescribed qualifications as well as the age limit.
Who? The petitioner?
My lord.
He doesn't have them anymore.
No, the age may become an issue, my lord, because if time is.
Of course, that can be condoned.
That is the only thing.
Yes. So, what is
Your Lordship, in this respect, I want to say that at the time of interview, her age is already over age, my lord. It is not within the age limit.
No, that is not correct.
Not within the age limit.
Have you filed affidavit in this matter?
Yes.
You filed?
Yes.
Have you made a statement? Number 6.
No, my lord.
Yes. We'll do one thing, then we'll post it. We'll give you a chance to be heard. We'll post it for hearing next week. Then we issue effective orders. Right, authority is a first paragraph. Before that first. Yes. It's taken on board and placed on report, right? And, next paragraph. This is matter for orders only after 1 week. In the order column, we'll finish it. You come prepared.
Item number 5.
My Lord, if all you file are objection, Your Lordship.
Where's the objection?
I've received the objection file. I want to file a rejoinder.
No rejoinder, Mr. It's to condemnation application. We'll hear the.
What can go for a hearing on this only. I didn't come
no,
for
we'll have a hearing. We'll have a hearing on this. Objections to the condemnation application has been received. I
have received.
This is a
We
matter
can have it.
This is a matter for.
Yes.
This is a matter after 1 week.
Yes.
For the orders. Yes.
1 week will be.
6.
I will be out 2 weeks here now.
Yes. Who's appearing here? Who's Mr. M. Sharma? Who's this? Mr. Ushla. None appears for the parties this of the 3 weeks.
7.
Please, Your Lordships. The contempt matter, my lord, where the security deposit was directed to be refunded. They have paid half, my lord. Now they want to negotiate.
Where's MS Colney? Who's appearing for the contempt?
MS Colney was appearing, Lord.
They want to negotiate, meaning how much have been paid?
Lordship, the total amount was around. I have been paid 1 crore 15 lakhs, and another 90 lakhs is.
9019.
90. Almost 50% is still remaining, Lordship.
Where's she was here just now? Where's she? Is that a fact? Are you ready for to renegotiate?
Some 50 lakhs is remaining. 51 lakhs. Total.
Where's she just?
And this is my security deposit. It is not a bill or.
Exactly. Yes.
My apology, Lordship. My Lord, with regard to reconciliation, my Lord, we have already made our calculation and we have given to the petitioner, my Lord. And the petitioner has not responded to the calculation which we have given. We are still waiting, my Lord. So, till yesterday, my Lord.
Is it a fixed amount of security deposit?
No, my Lord. There were some excess raw materials which were bought by the petitioner, my Lord. So, those calculation and deduction has to be done.
Raw materials and all is from the bill, my lord. Security deposit is given at the time of giving
adjustment has to be made.
Security deposit. How much security deposit did you give? Did you give at that point of time?
1 lakh 61,000 41,050. Oh, sorry, 1 crore 61 lakhs 41,050 rupees.
How much have you been paid?
1.3.
I have been paid, my lord. 1 crore 15 lakhs 95,224.
So still around 50 lakhs of
50
your
lakhs is still
outstanding.
So my lord,
if it's what do you call it? A limited amount you paid to him.
My lord, there was only some reconciliation.
Where's the question of unless they are deductible?
No, my lord, there were some items which he is claiming that which was not part of our my lord bill, my lord, which he is claiming. So we have to make the clarification which we have already given to the petitioner, and the petitioner has. In fact, my lord, till last evening I have this telephonic conversation with the corporation that he has responded. So my lord, but however, I don't have any material document, my lord. It can be closed, my lord, because it's a matter of small amount that has to be cleared.
Go negotiate was the point.
We are not negotiating.
Contempt is whether they have violated or
My
not.
lord, yes.
Now there's some
my instructions are very
quarrel
clear.
with amount.
No, lordship, what has happened here is that we filed a writ petition saying that running bills are being paid. The security deposit, you return it. The same amount that was deposited at the time of the giving of the work. It was never disputed, my lord, that there is something to be deducted an order came to be passed asking them to refund the security deposit, which is my money itself. Now they have
no. See, if there's some other outstanding amounts which you are to pay them, that had to be adjusted. Yes,
Well, that is what we are doing.
If that's the question, what's the question of contempt?
No, my lord, that should have been raised, if at all. I am saying that there is no question of any deduction now, because at the time of the writ petition, they have never made anything saying
the
that
writ petition
It's
was
a matter after 3 weeks to enable the petitioners to come to try to see contempt.
Lordship, there is no
It's not
contempt
going to be
any
in the
longer, my
picture.
lord.
It's between just to see whether there's any willful violation or
Yes,
not.
my lord, and we
If
are
they've
not
partly
going to
complied, they're
negotiate.
trying to comply with it. They've complied. Major compliance already been done. Regards to deposit, if they have some issues which you also have received some communications which you're examining whether any amounts are due from you to them. Then what does that mean?
Well, that is the situation which we are having right now. So there is no contempt, my lord. We have actually already paid them 90% of the payment.
There's not 3 weeks enable the petitioners to arrive at to come back with instructions. Yes.
Item number 8.
What is this?
It's a contempt. They file an affidavit stating that within 1 week they'll comply.
My lord, may I draw to Lordship attention. On the last occasion, Your Lordship have directed me to file the affidavit. However, on careful perusal of the contempt petition, there has been typographical error. Lordship, if may kindly take to page 4 and 5 of the contempt petition.
Page 5.
4 and 5. In the numbering of the paragraph, Your Lordship.
See, don't take technical objections. The thing is that you comply with the order. That's it.
Yes, Lordship.
Finish.
As per my instruction, Your Lordship have only comply, and I know
Only
that.
comply. What about the?
What if the other respondent is filing an affidavit stating that within a week they'll comply? The affidavit
Your name?
Melvin.
Your Honor, I'm appearing for the petitioner number 1, and I apologize for the delay. And apart from that, we will recommend to the subdivisional education officer within a week's time for the recommendation of the teacher.
You are the president of school management committee. Within a week, comply. We listen after 2 weeks.
Okay.
And we expect that the order will be complied by then.
Obliged, my
Yes. The affidavit has since been filed on behalf of the respondent number
1.
Respondent number 1. Stop. What's your name?
P. Naurum.
Stop. MSP Naurum. Council submits that the order is in the process of being complied, subject to certain official approvals that to be received from the state respondent. This is a matter after 1 week. There are 2 weeks.
Highly obliged.
Obliged.
Item number 9.
Your Lordship, we have complied with the order. We have forwarded the papers on the 13th of March.
This matter may be closed off, Your Lordship.
Yes, because the council of the party submit the order since will comply as such. Nothing survives consideration, the contempt or close and dispose of.
10.
Connected matters.
11.
Who am I? That person is complied with.
May I please, Your Lordship?
Yes.
Your Lordship, I'm filing my affidavit today itself, Your Lordship. I'm just waiting for signatures, Your Lordship.
I'm filing today. Serve an advance copy.
You're filing today?
Yes, Your Lordship.
MS Ailingwa, GA for 1 and 3, and Mr. Emanongpur for respond number 2. Submit after we find the cause of the day. When this is matter, you want to file rejoinders? After 3 weeks, after 2 weeks for rejoinder venue.
Obliged, Lordship.
12.
This matter, there was some talks of settlement. Some instruction has flown after the meeting, I'm praying this matter could be taken up on Monday.
I'm tired of this style of submission. So every time settlement has been
some letters have been issued to us. Perhaps we have to bring that on record also.
Settlement talks are complete.
Some to an extent, it has complete.
We'll record that.
Only, my lord, that settlement talk has now
What purpose
culminated
will be
into.
served by keeping this matter pending here? Are you expecting any further orders that you wish to seek from the court, or there's nothing else? Or the settlement proceedings are independent of what's the initial cause of which you came for this court? It's over. And then
Only issue, my lord, here again, my seniors.
you can't expect protection of the court to go on for further settlement or whatever concessions you might get from the
We
respondent.
would like to bring those letters on record, my lord. We'll do it by Monday.
No, but
itself.
bring on record what purpose will it serve? Will the court pass orders on the basis
Because
of
those
materials?
letters are still in the backdrop of, my lord, the PP proceeding being still pending.
No, not really. That's not correct, Willits. What's happened is there was a settlement. The understanding was that they would vacate the current premises and they would be allotted new premises once the building is newly constructed.
Right.
What's happened is that what they're asking, some of them are asking that temporarily, during the time that the construction takes place, they should be allotted temporary accommodations. That is not possible. It is not feasible at all. Now that is where we are facing a difficulty with some of the tenants. Some of them already vacated. Now in any case, that has not related to the PP proceedings. Separate notices have been issued to them only asking them to vacate because we were hoping that there will be cooperation from their side. There are some of these tenants who are creating some sort of an impediment. We don't know what the motivation is.
Lord, what my learned friend has submitted here, my lord, I am not privy to all those. My lord, that's why, my lord, I'm making a humble prayer, my lord. If this could be fixed on Monday, my lord, could be taken up on Monday, my lord. By then we'll come up with some concrete instructions on the matter. My lord.
Okay. Mr. S. Thapa, on a consideration, submits that settlement talks are complete. It said,
They have not agreed to the suggestions made.
we're not going to go into that, Mr. Thapa. This court,
if
it come with a specific cause which was addressed and the orders were passed and your interest was protected, your building was not knocked down.
That is why, my lord, I'm not really, my lord, equipped with the complete instructions. That is why, my lord.
Mr. Thapa prays that the matter is on Monday. We'll enable him to obtain complete instructions in the matter. All right. Just accordingly.
13.
Please, Lordship, as per last order, I pray further 1 week time to file application to complete JHTC, Lordship. Because earlier
completed them.
I will file an application, Lordship. Just I asked only 1 week's time because actually it is prepared, but petitioner is out of station.
Mr. Praise has allowed 1 week's further time to file implement petition.
Lordship.
Yes. Yes, there
Authorised, Lordship.
14.
May I please, Lordship? The state has to file an affidavit.
May I please, Lordship, in this case, Your Lordship, I need 3 weeks time to file the reply.
What about the private respondent entering appearance today?
I'm appearing for respondent number 5, 6, and
Number?
5, 6, and 7.
That means all of them. Okay.
Yes, my lord.
Yes. Mr.
Arif
Arif
Akon.
Khan.
Arif Akon.
Oh, Arif Akon. Okay. Mr. Arif Akon sent an appearance today on behalf of 5, 6, and 7. You require time to file affidavit? You won't file affidavit?
Yes, my lord.
And praise allowed how much time? 3 weeks time to file affidavit, yes.
Granted.
Yes, praise allowed. Similar prayers made on behalf of the response 1, 2, and 3 just after 3 weeks for affidavit.
15.
Your blessing.
The records?
Your Lordship, the records are here. They are in a sealed envelope, Your Lordship.
You ready with the matter, Mr. Robme, right?
Yes, Your Lordship. Your Lordship, actually the arguing counsel, he's having some personal difficulties. He could not attend this on our court today. The arguing counsel beat up.
Here, what's the problem? Is he absent on, he's not well?
I'm not aware of this entire matter, Your Lordship.
The records as directed have been produced today by the respondents 2 to 5 stop. However, prayer has been made on behalf of the petitioner, Mr. B-Deb, who stated to be not able to go due to personal difficulty. What to do, Mr. Barsaji?
My thing is what the prayer. Whatever the thing, my lord, there is no prayer.
Lordship, we can have
relief from this court. The petitioner.
We can have the matter on Monday, Lordship. Yes.
No objection.
Make sure it comes on Monday.
Okay.
List the matter on Monday. The sealed envelope containing the results is kept in the custody of the court. Yes.
Highly obliged, Lordship.
16.
Please, Your Lordship. Appearing to the respondents, my lord, I was served copies and we've received instructions, but the instructions are not complete. I've asked for some additional instructions. I just pray for another 3 weeks' time, my lords.
You told me before entering, I have no objection yet.
Yes, sir. Mr. SN, please for the 3 weeks' time to obtain instructions.
Highly obliged.
Yes.
17.
May I please, Lordship?
Yes. Rejoinder file
time for the petitioner item, not yet, my lord.
Why?
Further 2 weeks time will be granted, my lord.
2 weeks for a time granted to this petition affidavit. Just thereafter. Yes.
18.
My lord, keep your Lordship.
18.
And 18, my lord, I am for the petitioner and affidavit in opposition has not yet filed, my lord.
Your Lordship, we are praying for 3 weeks' time, Your Lordship, as we have not
The
received any
first matter,
instructions.
correct. MS from South Vice Dr. N. Muzika, DGSI, prays for her for the 3 weeks time of an affidavit. Just thereafter and so on.
Much obliged.
19.
Much obliged, Lordship.
Please, Your Lordship, I am yet to receive instruction in this case, Your Lordship. On behalf of state respondent number 1 to 3.
Really 1 month. Not getting instructions.
No, Your Lordship.
Who's the officer concerned?
So this is Director of School Education here in Shillong,
Same
and
matter.
other is Subdivision School Education Officer, Dadingli.
Ms. MS Barasaji for 1, 2, 3 and MS EB Pasa for spot number 4, pray for and allowed further 3 weeks time of an affidavit.
Much obliged.
Hello, please.
20.
Yes, thereafter also.
I'm praying for some further time for instructions, Lordship.
So, when are you paying him?
Lordship, we have communicated to the
To his partner?
to the district council, my lord. We are waiting instructions.
Since, waiting instructions, if this is money, sanction number, why don't you leave to him?
Pending salary.
Pending salary, yes.
We have communicated, my lord. We have also expressed that
Because they have admitted it's my money. They know they.
Of course, it's your money.
They should release because I have nothing, only relying on this.
Mr. SDEP prays for further 2 weeks time to obtain instructions. Expected that on the next date, positive instructions will be forthcoming from the response number.
all the respondents.
From the respondents.
21.
Highly obliged, my lord.
So 21, my lord, I'm praying if the matter can be taken up on Monday, we will complete our instructions, Lord.
Lordship, this matter is connected with item 21 as per your Lordship's last
This is
order.
21.
23, your Lordship. This for the matter of Galavi.
Regarding?
Lordship, with regard to the supply of this animal fodder.
Oh, no. We'll hear it, yes.
On Monday, my lord.
No, Monday. What Monday?
No, only we want to, my lord, see whether the money suit will be.
My lord, may in the check. My case is one of the case here. Just recently, I got the instructions. 3 agencies were selected. Case number 1, I know so. And another person, Mr. Contempt. Now, last month, the district disaster management authority has released the amount. The same contract, same disaster.
No, but same contract for the same supply.
Yes, same.
That means they didn't supply. He only supplied.
3 different contracts for 3 different
Three agencies.
contractors, Lord.
3 agencies. same natural disaster, same quantities, same amount.
These things happened in 2014, correct?
Yes.
Flood, yes,
Do you think sitting now here in 23, we can assess what was the the amount of feed that you fed these animals?
May I pray, let the respondent bring the records.
What records?
Payment of,
You have come up with that. You bring if you have any materials to show that a similar situation, another contractor or another supplier has been released the amount, and the factum of your supply is not indicated anywhere. And even whether it was the relief camp or whether the feed was given somewhere else also is not clear.
Madam, in my case, they have 5. Whether the department has 5, it is there already. Subject to lordship's later.
Even in this one.
I may obtain throughout day, but that will prolong the litigation.
No, but how are you aware about this?
My lord, we were
Where do you get information from?
We were informed by the department that the 50% of the amount has already reduced to another third person, the third agency.
Is that correct?
Just allow me. Let them obtain instructions. Let them make about the.
What is the name of that other agency?
My lord, Contempt Prasad. In fact,
is that correct?
Yes, yes. The information I received.
Gautam Prasad. Gautam
Prasad.
When was the amount released?
Correct, but the enterprising name is. I just give the correct name.
Please.
Gautam Enterprise. Gautam Enterprise, but it is a proprietor is a Gautam Prasad. Gautam Prasad.
So, hold on. This item 21 and 23 together. Take down when these matters were called out today. Stop. Call out to the comma. Mr. H.L. Changreso, Senior Counsel, in item number in WPC number 279 of 2021. The price of what that a third contractor, a third similarly situated contractor which supplied the animal feed has since been paid
50% of the amount.
50% amount by the state respondents. Stop. It is also further stated, further informed that, or further, the name of the firm as per the senior counsel is Gautam Enterprise. Stop. If this is so, next line. If this is so, the matter will need rehearing. Because this court's already made up its mind with regard to what to do these matters.
I would pray, my lord, because my matter at 21 is still in the orders column. It may be time.
Doesn't matter. It'll be tagged together. Will it rehearing? Stop. Accordingly, the state respondents, the GFC was directed to obtain instructions as to whether this submission has been made by the legislative council before this court today is correct. So this is a matter after 2 weeks.
It's released by district disaster management DC.
No, but depends on what was the form of the the terms of the agreement and the contract. It might be different. It's just that the court satisfied itself that there's no discrimination. That's all. Yes.
Hearing supplementary list item 3.
My lord, the challenge to the departmental proceeding where I was removed for service, lordship.
Over. You already heard
Yeah,
it.
it only take a minute, my lord, to just put it together. Here, my lord, I was appointed in 2001, lordship, and I came to be terminated for an absence of 93 days, lordship, between 14th December to 18th of March, lordship. And the punishment that was given to me was removal for service. So on the last occasion, my lord, I had stated that the initial notices for resuming duty were given to me in my home address at Bihar, whereas I was lodged here in civil hospital lordship. So I did not, I was not in a position to receive those notices. And at the time of the departmental inquiry, my lord, I had submitted my reason for why I was absent, being the hospitalization, and that was recorded in the departmental proceeding lordship.
Yes.
Subsequently, I had the disciplinary authority had removed me from service. I filed an appeal lordship, and the appellate authority confirmed the removal from service. And challenging that appellate order, we have come before this court. The main ground, my lord, was the absence, which I am charged with, my lord, was
not willful,
lordship, because it was for the reasons of occupation and illness. And secondly, my lord, I had stated on the last occasion that they had the occasion. It was not the fact that they did not know, my lord. Only to substantiate that, lordship, I only have the affidavit at page 4, lordship. Page 4, my lord. Page 4, lordship, and the third paragraph, it is submitted.
Yes.
It is submitted that the respondent authority, on receiving the medical certificate in good conscience and good faith, having sympathy upon his family, unauthorized leave of the petitioner was considered and adjusted. So what I had stated, my lord, that this entire illness was a single tranche. So in between, they had already drawn up previous disciplinary proceedings where I had submitted the reason, and based on that medical certificate and everything, they had, my lord, given me initially they had given leave without pay, and I was also given extraordinary leave on medical ground. So they were well aware since 2018 that I was having this issue, my lord. And then this instant disciplinary.
See, this condemnation was for a period.
Lordship, this condemnation was period of 83 days, my lord. In total.
28/6/2018 to 8/7/2018, and now you said that you've been absent for, as per submission, 14/12/2019 to 18/3/2020.
The 2 points, my lord. First is from.
Now you're trying to say what you. I understand what you're trying to submit is that my illness is known to the respondent.
Yes, that is the only thing that they knew it.
Because my earlier period of absence
was condoned as
I didn't inform them, they condoned. And so second absence also, since I didn't inform them, is their duty bound to condone also, since they're already aware that I'm a sick man. I trying to say that.
No, I'm only trying to say that they were.
That's what you're submitting, that they are aware of it and then early on have condoned. So what's preventing them?
Because on the last occasion it was unclear whether
can that be a valid submission?
No, I'm not submitting that. What I'm only trying to say, my lord, on the last occasion it was unclear whether they knew or not that I was hospitalized. So I'm saying that this is.
So they knew you're hospitalized. So that's why, and then you have not given one scrap information to them where you are or what you're doing. And so you expect them to have, this extra sensory perception that, that poor fellow, he must be, ill. So let's condone his leave.
My medical certificates were always with them. They always knew where I was, exactly what I was suffering from.
Okay, continue. Yes.
So they knew, my lord. Now this instant disciplinary proceedings ranged to the period of 93 days between 14 December to 18th of March, lordship. For this, they have removed me from service. So as a result, I have like I said, my lord, I was appointed in 2001, and I have served for 19 years till the time this period comes to play, lordship. And now I've been removed from service. My entire service has been, my lord, made obsolete in essence, lordship. No pension, no benefits, nothing. So, on ground of proportionality, lordship, this honorable court has enough jurisdiction, my lord, to examine whether the punishment was proportional or not to the offence that I have been charged with, my lord.
So, limiting your arguments to quantum now.
Because
so you're not challenging the proceedings or the impugned removal order.
No, my lord. My first ground is that the impugned order itself bad because there is no finding to the effect that my absence was willful. And the law which I had, my lord, relied on the last occasion by the judgments of the Supreme Court say that there, in a case of charge for unauthorized absence, it has to be proved that it is willful. Nowhere, my lord, in the impugned order or in the initial disciplinary proceedings is there a finding that my lord, these medical certificates are questionable. That is why this cannot be.
So you say that the punishment imposed upon you is too harsh.
It's harsh, and it is not for an absence which was willful, Lordship. It was absolutely because of compelling circumstance. And only one more judgment I would like to add.
No, 1 second. Let me just. You say that it is harsh because it's not willful, and the medical certificates have not been disputed.
And they knew, for 93 days of leave, my lord, to remove me from service is the harshest punishment, which is not proportionate.
Okay. No willful absence. Yes.
My lord, I will not repeat those earlier judgments. Only one fresh judgment, my lord, which I would like to. It's very.
You repeat, no problem, because the sport's forgotten.
Then I don't have. Lordship, this is a rather relevant judgment, recent judgment, my lord, of 15th March.
There's no equivalent citation from SEC or from AIR or from SC Online. This one?
15th March 23, my lord.
Okay.
So, here, my lord, the fact was that he was appointed in the Eastern Coalfield, my lord, and he was absent. And here also, my lord, earlier he was absent and those were condoned. So, those could not have been considered for this lordship. So, lordship may come to the second running page, my lord. I would like to read from the first paragraph. It is true, as contended by the learned counsel for the appellants, that while imposing the penalty, the employer is entitled to take note of the antecedents of the employee. But the antecedents cannot relate to the very same misconduct which did not lead to any action. So here also, my lord, the same reason, the same illness, the same charges were drawn of unauthorized absence. They had my medical certificates in good faith, in good conscience, with application of mine. They have condoned it, given me the extraordinary medical leave, my lord. So those previous leaves, my lord, may not be considered.
Yes.
Though the learned counsel for the petition appellants tried to distinguish the two decisions relied upon by the division bench in the impugned order, namely Union of India and others. And
now, when you say a service unblemished, you've been absent for how many occasions before this last infraction? See, if you're looking at an employee who has a service record, unblemished, and suddenly one fine day, poor fellow, for some reason, he's some DP drawn up against him, and they give the penalty of discharge or removal, then maybe in those cases, maybe that it might be too harsh. But if it's a person is a habitual, absentee, unauthorized absentee.
It's not habitual, my lord. I am saying that right from the very beginning, he was suffering from this ailment. Medical certificates always
ailments. What's the ailment?
It's alcohol dependency syndrome, psychiatry and other psychiatric ailments.
Okay.
So he was not in a position to even, my lord, inform, because he was undergoing treatment also. So I would say in this judgment also, my lord, it has been held that only on the number of days may not be a factor, but my lord, the court should be satisfied that the punishment is proportionate, my lord. And here in this case, there was an absence of 106 days. In my case, my lord, there is an absence of 93 days. So for 93 days, my humble submission would be, my lord, that even if there is no reinstatement, at least compulsory retirement would be the best punishment that they should have, my lord. Because to absolutely obliterate my 20 years of service at this stage, my lord, for an absence which is not willful because of medical grounds, compelling circumstances, may not be, my lord, sustainable.
Yes, Mr. Varsaji.
Yes.
Right, please, your lordship. So far as my learned friend's argument is concerned, my lord, he started with saying that no opportunity was provided to him, and then he said that, my lord, that the fact that there was willful absence, that has not been proved, and my lord, he questioned the proportionality of the punishment. These are the three headings. Now, my lord, just to my lord, the counter the first leg of his argument that no opportunity was given. My lord. I'll do your lordship attention to the Annex 9, my lord, page 36 or affidavit in opposition. There is a copy of the proposal. Page 9. Sorry, my lord, Annex 9, page 36 of the affidavit in opposition filed with the state.
Page 36.
My lord.
Yes.
Now, my lord, lordship, you will find this is show cause notice, my lord. And that has been below, it has been signed by the petitioner, Amjad Khan, on 18/3.
Page 36. Yes.
My lord, on 18/3, my lord, he has received it. Now, my lord, a perusal of the notice should say that he has to submit his written explanation within 7 days from the date of
within 10 days.
completion also, my lord. Now, my lord, he has not chosen to do anything. He has remained silent, my lord. He has not replied to it, and he has nowhere stated that his absence was not willful. That he has been prevented by certain reason for which he could not report also. That is not me. My lord, I am saying it because, my lord, I will rely on the very decision which my landlord friend has relied upon. My lord, I will be relying on certain paragraphs from those decisions. Now, my lord, his first contention, the first part of argument that no opportunity was given, my lord, it is, my lord, it would not stand, my lord. My further, my lord, if lordship peruses the order of the Department of Authority, my lord, well, if lordship, my lord, I can take your lordship, my lord, to Annex 12, my lord, page 51 of the writ petition, my lord. Now, of course, my lord, my landed friend had gone through those documents, but then he has taken your lordship only to those parts which help him. And as a matured lawyer, my lord, he has skipped the other parts which, my lord. Lordship, I just draw your lordship to attention to paragraph page 52, my lord.
Yes.
The second subpara, my lord. During the course of inquiry, my lord. It starts with
Yes.
all opportunities are provided to the delinquent and to cross-examine the prosecution witness during the recording of statements. Ample opportunities were given to the delinquent, keeping in mind the principle of natural justice. The statement of the delinquent and the statement of the prosecution witness were recorded by the EO. But at the time of deposing of PW, the delinquent declined from cross-examining any of the witness. Now, he was given all the opportunities, my lord.
Next paragraph.
My lord.
Let him plead, yes.
Now, my lord. The prosecution witness all the time of deposing had stated that a delinquent was found to be absent from duty from 14 through 19. Now, what date helps him tell it? When he was detailed for night law and order duty at Shillong. It was also stated that the delinquent only resumed his duty on 18 March 2020 after being willfully absent for a period of 96 days. The delinquent himself also admitted that he remained absent from duty from 14 June as he was suffering from psychiatric ailment. Now, I was about to give it because he was himself admitted, my lord. Now, my lord, this will have a relevance so far as the decision cited by him is concerned, my lord. Now, my lord, these are the things, my lord. So, he is definitely, my lord, so far as first submission is concerned, my lord.
He's been given enough opportunity.
So, that has no left. Now, my lord, he has come and he has said, my lord, his second condition is that his willful absence has not been. My lord, he is not disputing the fact that he remained absent unauthorized. Now, what he is saying that unauthorized absence is not willful. Now, my lord, if there was any explanation coming from his side with regard to his unauthorized absence, my lord, this could have been termed either as willful or not as willful. Had he offered any explanation, my lord? He has not offered any explanation. So, if he has not offered any explanation, my lord, he cannot raise that. And my lord, he has basically admitted that. Now, my lord, so far as the proportionality is concerned, my lord, that would stand answered, my lord, if I can take your lordship, my lord, to our affidavit in opposition, wherein, my lord, a detailed history of the person's absence from duty, right from the day he joined, my lord, has been narrated, my lord, and that is not been refuted. My lord, Lordship may kindly come at page 15 of the affidavit of opposition.
50.
15. Page 15.
Yes.
Now, my lord, at the bottom, my lord, the last paragraph, I'm just reading the subparagraph, my lord. The petitioner appeal against the order of removal later so and so, however, the appellate authority opined that the punishment commensurate with the nature of misconduct and the petitioner has perpetrated throughout the service. On detailed analysis of his service records, the petitioner has found to be habitual absentee, disobedient, delinquent, and imprudent towards his official duty. The details below as evidenced substantially is the same. Now, Lordship, the 1, 2, then Lordship may kindly, my lord, turn what next to my lord. There are 12 instances, my lord. Now, my lord, every time, my lord, he has been retained.
And even item 7, 343 days you don't pay.
My lord, every time, my lord, he has been accommodated just in the hope that he will correct himself, my lord. He has not done so.
Yes.
And my lord, all those incidents, all those facts are not denied, my lord.
Yes.
Now, my lord, that would answer his, my lord, plea about the proportionality. Now, my lord, just to, my lord, buttress my argument, I would just take your lordship to the very decisions which my learned friend has relied upon, my lord. Now, my lord, he has referred, my lord, 3 decisions. One is 2008 SCC, my lord, page 469.
8 volume?
2008 8 SCC, page 469. The State of Punjab Doctor versus Dr. P.L. Singla. That has already been.
Yes, please.
Now, my lord, lordship, if lordship kindly comes to paragraph 13, my lord. My lord, may. The lordship got it.
Yes.
Right. We may note here that a request for condemnation of the absence may be favorably considered where the unauthorized absence is of a few days or few months and the reason for absence is stated to be sudden serious illness or unexpected bereavement in the family. But long unauthorized absence are not usually condoned. Now, the last line. In fact, in security services where discipline is of utmost importance, even a few days of work stay is viewed very seriously. Now, my lord, 2 things, my lord, here also it says that he has not come with any explanation, my lord. Now, my lord, this part of the decision, my lord, has not been, my lord, previously. So, my lord, the second decision, my lord, is 2009. 15 SCC page 620, my lord.
620.
My lord. That is Chairman cum Managing Director versus Coal India Limited and another versus Mukul Kumar Chaudhary. There also, my lord, I will start from paragraph 13, my lord. Page 67. It has been time and again said that it is not open to the High Court to examine the findings recorded by the inquiry officer as a court of appeal and reach its own conclusion, and that power of judicial review is not directed against the decision but is confined to the decision making process. In a case such as the present one, where the delinquent admitted the charges, no scope is left to differ with the conclusion arrived at by the inquiry officer without the proof of charges. In the absence of any procedural illegality or irregularity in conduct of the departmental inquiry, it has to be held that the charges against the delinquent stood proved and warranted no interference. Now, my lord, I'll just bother your lordship by reading another 2 paragraphs, my lord. Lordship, paragraph 20 and 21, my lord. Because it is quantum and proportionality.
Page?
My lord, page 20, page
634,
page paragraph 20. one of the tests to be applied while dealing with the question of quantum punishment would be, would any reasonable employer have imposed such punishment in like circumstances? Obviously, a reasonable employer is expected to take into consideration measures, magnitude, and degree of misconduct, and all other relevant circumstances, and exclude irrelevant matters before imposing punishment. Now, Lordship, next paragraph. In a case like the present one, where the misconduct of the delinquent was unauthorized absence from duty for 6 months, but upon being charged of such misconduct, he fairly admitted his guilt and explained the reason for his absence by stating that he did not have any intention nor desire to disobey the orders of the higher authority or violate any of the company's rule and regulation, but the reason was purely personal and beyond his control. And as a matter of fact, he sent his resignation, which was not accepted. The order of removal cannot be held to be justified. Now, my Lord, Lordship will note here the two aspects, that he has offered his explanation, my Lord. He said that it's not intentional. And second thing is that he has offered to resign, my Lord. Now, this is not the case here, my Lord. This is not the case here, my Lord. In the present case, my Lord, nothing of that sort had happened.
Yes.
Now, my Lord, in this case, my Lord, the factual background was totally different, my Lord. So that, and even, my Lord, the proposition of law laid down in that case also, my Lord, it helps.
Yes, applies. Yes.
And my Lord, the another one is my 2012, my Lord. 3 SCC page 178. Pushkant B. Parmar versus Union of India, my Lord. Now, my Lordship, just comes to paragraph 17, my Lord. Just first line of paragraph 17, my Lord.
Yes.
In the absence, if the absence is in the result of compelling circumstances under which it was not possible to report or perform duty, such absence cannot be held to be willful. Now, my Lord, there has to be compelling circumstances, and the circumstances which would prevent the delinquent to report to the tribunal. Now, here, my Lord, nothing of that sort. Nothing, my Lord. He has never offered any explanation. He has never offered any explanation saying that he was not in a position to, my Lord, even to report. Now, if Lordship further goes to, my Lord, comes to paragraph 21, my Lord.
Yes.
In the present case, the disciplinary authority failed to prove that the absence from duty was willful. No such finding has been given by the inquiry officer or the appellate authority. Though the appellant had taken a specific defense that he was prevented from attending duty by so-and-so, who prevented him to sign the attendance register, and also brought on record 11 defense exhibits in support of his defense that he was prevented to sign the attendance register. This includes the letter number so-and-so, another received from such and such so-and-so, but such defense and evidence were ignored, and on the basis of irrelevant fact and surmises, the inquiry officer held the appellate guilty. No defense was, my Lord, offered here. He has not brought in anything. There is no such allegation by him that he was prevented from attending duty, my Lord. So this decision also not come to each my Lord. Now, my Lord, I would rely upon a decision, my Lord, in addition to this, my Lord. This is 2005-13 SCC page 709. My Lord, I have not given
2005
13 SCC page 709.
Yes.
My Lord, I will rely upon paragraph 6 and 8.
Para 6.
My Lord, at page 711. May I read, my Lord?
Yes.
One cannot ignore the large number of cases which come to this court of members of uniformed forces remaining absent from duty without any reasonable explanation. Whenever action is taken, the usual plea taken is of having been ill or some such false pretext, and even fake or false medical certificates are produced in support of such a plea. We would not have taken a serious view of the matter had it not been a case of a constable belonging to CRPF remaining absent for an indefinite period. Even if we assume that that the respondent was suffering from depression and was being treated as an outdoor patient, the medical certificates produced by him show that he was restored to normalcy on 4/4/98. Yet the respondent did not choose to report for duty. The order of dismissal was passed 7 months later, that is on so and so. This itself discloses the hollowness of the claim of the respondent. My Lord Lordship, my Lord, I will put special emphasis on this because the circumstances we will be putting forward here, my Lord, in factual aspect, Lordship will find more or less similar to it. I'll just come to that, my Lord, after I finish reading this. Now, Lordship, thereafter Lordship proceed to paragraph 8, my Lord. The present case is not a case of a constable merely overstaying his leave for 12 days. The respondent took leave from 16/6/97 and never reported for duty thereafter. Instead, he filed a writ petition before the High Court in which the impugned order has been passed. Members of the uniform forces cannot absent themselves on frivolous plea, having regard to the nature and duties enjoined on these forces. Such indiscipline, if it goes unpunished, it will greatly affect the discipline of the forces. In such forces, desertion is a serious matter. Cases of this nature, in whatever manner described, are cases of desertion, particularly when there is apprehension of the member of a force being called upon to perform onerous duties in difficult terrains for an order of deputation which he finds inconvenient is passed. We cannot take such matters lightly, particularly when it relates to the uniform forces of this country. A member of the uniform force who overstays his leave by a few days must be able to give a satisfactory explanation. However, a member of the force who goes on leave and never reports for duties thereafter cannot be said to be one merely. Of course, the last part will of these things he has come back, but he has to explain even for few days when he is absent. That is what the law is. Now, my Lord, coming to his case, my Lord. Now, my Lord, what happened? Now, my Lord, I have pointed out to your Lordship, my Lord, this on all other previous occasions, my Lord. He has been, my Lord, basically inflicted with minor punishment. At least he was retained in the service, my Lord, in the hope that he will be corrected. Now, my Lord, on the last occasion, my Lord, when he joined, my Lord, he came back with certain medical certificates. Now, this he has appended, my Lord, at Annexure 8, page 16, my Lord.
Writ petition.
Of the writ petition. My Lord, those certificates.
Annexure 8, page 16.
Page 16. 40, sorry, my Lord, page 46, my Lord. Sorry, page 46. I'm sorry, my Lord.
Yes.
Now, my Lord, you will find these certificates are undated, my Lord. There is no date of doctor signing it. The digital certificates are not there. Now, Lordship may kindly come to the next page, my Lord. Here also, Lordship will find the date column is missing.
Yes.
Then, my Lord, now, my Lord, Lordship will find the next one also is same. Now, my Lord, kindly, my Lord, come to Annexure 10, my Lord, though it is undated. Now, Lordship will find what it says. I, Dr. So-and-so, after careful examination, certify that the Amjad Khan, that is a petitioner, on restoration of health is fit to join his service with effect from 15 to
2020.
Now, my Lord, take the date on which he joined. He has joined on 18/3, my Lord. That is why I was referring to that specific paragraph in 2005 decision. There is no explanation came, my Lord, why he remained abstained from 15 to till 18/3. Now, my Lord, that would be, my Lord, a parent thing, my Lord, which would project his case, my Lord. So, my Lord, that is what I feel, my Lord, that is not case, my Lord, where he should be shown any kind of leniency. And, my Lord, on the top of that, my Lord, the lacquer was called for this matter, which I have pointed out, my Lord. It was placed before the court, this thing, but then, my Lord, that was returned back on 30th.
Mr. Deb, anything to say?
So only on the last occasion, my Lord, I had referred to a judgment of the Allahabad High Court. Why I was referring to that, my Lord, because that is more or less, apart from the fact that that is not in the police department, the entire facts are the same, my Lord. That the
Allahabad High Court, it's a division bench judgment?
No, my Lord, it's a single bench.
They don't have any, it's just possessive value.
But they have, my Lord, referred to all these Supreme Court judgments cited by both of us.
You're not bound by it, yeah?
No, it's not bound, but I had already placed it.
Let's see it. To satisfy you that you also bring adequate opportunity.
My case, my Lord, was in paragraph 18 of the judgment of 2012 SCC, my Lord.
Now come back, this is Allahabad dated?
This is 9 July 2014.
2014. Which paragraph you are referring to?
Lordship, 6th paragraph, submission of the learned counsel of the petitioner.
Yes.
Is that even accepting the allegation as correct, that the petitioner had proceeded without information, though it is denied, that the petitioner on his return had given an explanation for his absence, which was on the ground of medical illness as well as his wife's illness, the petitioner on return had submitted the medical certificate, which none of the authorities has disputed its authenticity or credibility. The illness of the petitioner was not disputed by the authorities, hence absence from duty was not willful. In the facts and circumstances of the case, petitioner could not have terminated the service in support of a submission. Learned counsel has relied upon the cases of Koshakan B. Parmar and another, Sham Charan Tripathi versus State of UP and Virendra Kumar. So these are on the same lines, my lord, that the absence for compelling circumstances such as hospitalization and illness does not amount to willful absence and misconduct. Unauthorized absence, my lord, I cannot refute it, because if I have been absent, I have been absent, my lord. What has to be seen is that that absence was willful, therefore it was amounting to misconduct.
Now only one thing, you see, Mr. Dev. We just start from the we're not sitting in appeal. We start from the basics. Is that look, we have to see, you have to show the court that the proceedings were irregular, you're deprived of opportunity to be heard, and okay, quantum is another aspect. Now you were given show cause. That is you can see it very clearly. You received it. You refused to even give a little reply.
My submission was the initial show cause to resume the duties were not.
No, the other show cause for you to run it department proceedings. You never show cause, you never bother. And even when the proceedings were going on, you didn't bother to cross-examine, you didn't bother to adduce any evidence.
No, I have given my medical certificate, my lord.
Medical certificate, what will it speak? Even those undated?
No,
and even when what is the little AG shown? From that other certificate, you're fit to join duty on so did you go? Can you take the plea that I was depressed?
No,
I was on psychiatric. I'm having psychiatric ailments that prevented me. That you couldn't read those papers also.
No, my lord, I'm not. These certificates are disputed.
This case is a very small case. Only we've given you an opportunity because
these certificates have seemingly been disputed now, my lord, at the stage of the disciplinary proceedings and in the appellate authority.
If you didn't bother, even to place them, you didn't bother even to like rely on them in the proceedings. What are you going to say?
It was there, my lord, which is why I have in the inquiry, as my learned senior had said, that I had admitted that I was absent because of this reason, because of my ailment, and I am given the medical, my lord. I have not admitted that I have been willfully.
Why didn't you show cause?
Lordship, show cause was I have stated in the initial petition also, as well as in my appeal also, as well as in
why didn't you show cause?
I did not show cause, my lord, because I was under the bona fide belief that the time has elapsed. That was
what time has elapsed?
That was because the show cause.
You can't. It is not a proceeding under some procedure code. Something you can easily. If you wanted to show cause, you could have filed a show cause.
Yes, but I have participated in the inquiry, my lord. Just because I did not file a show cause does not mean that I have not given any explanation. If I have given the explanation in the inquiry itself, and it was never refuted that my illness was never refuted, my lord. And for 93
so what do you say about your past conduct?
Past conduct.
See, comes the quantum now. Do you think your past conduct will justify lesser punishment?
Lordship, I would humbly pray that the worst, my lord, punishment that assuming that it is proved to be willful, they should have been put for compulsory retirement, my lord. Otherwise, my entire service is, my lord, absolutely washed away by. And for a reason which I continuously say, my lord, because none of my absences was because of any other reason, but it was because of this very reason of alcohol dependency syndrome and other related psychiatric ailments, which, my lord, and if I am in the hospital, it is not possible for me to, my lord, to resume the duty with this kind of a psychiatric ailment, my lord. Psychiatric ailment, even the senses and the rationale of the person also are affected, lordship.
What do you write in the appeal memo? We haven't seen that.
I have taken all those pleas, my lord.
Let's see that.
Lordship will find my appeal memo at page 55, my lord, annex to 13 of the writ petition. Starts from page 55, lordship. So the amendments start from page 58 onwards, my lord, where at paragraph 3 onwards I have stated right from the period before this instant period of absence, my lord, that I was undergoing this same treatment under the same doctor in the same hospital, and certificates were issued to me.
Why did it not come forward in your show cause?
No, my show cause, my lord, I did not submit because I was under the bona fide belief that the 7 days time has elapsed, my lord. That was because of the misinterpretation of the, because he is constable rank, my lord, he is not very, perhaps by the language of the, he is assumed it, and that has been stated in the petition, my lord. So I have the grounds lordship will find. Begin from page paragraph 18, my lord, at page 63. Sorry, my lord, paragraph 15 at page 63. Appellant begs to state that during the course of inquiry, the prosecution state, this is from the inquiry, my lord, where I had, in the time of the inquiry also, I had said that I was absent because I was suffering from these ailments. It was never refuted. Thereafter, my lord, again at paragraph 18, I have said that the respondent authority has ignored the medical condition of the petitioner, my lord, and the same judgment has been referred to thereafter. And again at paragraph 21, my lord, is that the reason has to be examined and the finding has to be there, my lord, that it was willful and the medical.
In the first order itself, that is willful.
No,
the first order in court, or should we pass it?
Go through the, because I am hopeful, my lord, that at least compulsory retirement, at least I'll get my terminal benefits, my lord. That is the hope, what I can pray for at this stage. But even otherwise, it is not willful, my lord. It should not have been.
Okay.
One thing, my lord, I have omitted to say, there is a newspaper, my lord, publication also, with regard to his absence. My lord, that is at page 35. I actually read our affidavit of position. Should have pointed out.
Newspaper?
Publication, my lord, with regard to his unauthorized absence, asking him to join. This Sri Lankan Times dated 18/1/2020.
Annexure?
8, page 35 of the affidavit of position.
Why is there so much alcohol affliction in this process? Do you know that this is not only a case? There are hundreds of them.
Only 93 days, my lord.
No, but earlier on they condoned. Look at that. How much can you condone? So the 343 days, 73 days, 10 days, 15 days. I can understand. Quantum of punishment can only be looked into your past track record.
Of course, my lord, of course. But
suppose you had whatever blemish, then you suffered. Then.
No, my lord, because if they have condoned, they cannot look into it.
You know why? Why did you take it so lightly? What's the reason?
My lord, there was no.
Why the reason? Why is the reason that you took it so lightly? I mean, the petitioner. Because 12 earlier occasions, he was let off.
No, my lord.
And on 13th, he got unlucky.
No, the
13th was unlucky for him. That number. That's the only thing. On the 13th time, then they said remove from service. 12 infractions earlier on, even one absence 343 days. That's even that's regularized.
No, but the judgment which I relied on today, my lord, clearly says that if they have condoned it, they cannot look into it now.
They are not looking into that. But the employer has every right to look at antecedents. While looking at quantum.
But they
now
have
suppose
not given any punishment, my lord.
You expected that it'll be condoned again. Because the last absence in 2018, which you were absent for how many days, they condoned it. But how can you expect them to be, to give that much of concession?
If they have condoned it, not mean that his absence was due to alone. This
cannot be absorbed. Cannot be absolution. It cannot be absolution. You cannot be charged on the same grounds. Correct. But then this is a new period of absence you've done, but they are equally entitled to look into antecedents.
Yes, my lord. But if they haven't taken any action,
yes,
they cannot come and say that I have been already charged with this. Because they have condoned it, my lord, rightly or wrongly.
My lord, in all 12 earlier occasions, my lord, there are also no prior information by him, my lord. Every time he joined.
That is why he
has his family members. We have mobile phones, my lord. My lord, nothing. Yes.
No.
He is not.
See, it's your fault. Whose fault is it? 12 occasions earlier on, you condoned his absence.
My lord, probably.
And he came back to service, and even he was fit, declared fit, also he didn't bother to join. So what are you going to do?
My lord, we are full
Do
of.
you expect any compassion?
I will only pray, my lord, that
That number 13 should be lucky.
No, I would pray, my lord, that the punishment is still too harsh. Compulsory retirement would have been a more, my lord, proportionate punishment.
It should have been harsher, man. It should be dismissal, my lord. If it is removal, my lord, at least he will have.
You can easily have to re-employ yourself.
No, because, my lord,
You can join some security agency. Yes.
That is, my lord, there, but here, my lord, I strongly urge.
We,
my lord,
court
that-
appreciates the effort that you put into this matter.
Because
Mr.
I
Deb.
am still, my
You want
lord-
to record that also. We
sure,
appreciate the effort that you put into this matter, to argue it and to prolong it for how many days? on 3 points.
Only, my lord,
So anyway,
because I still, my lord.
we'll examine. Suppose somehow, some little glimmer comes, then maybe there might be some concession.
Only, my lord, just because in the show cause I have not given, in the disciplinary I have taken the
Enough. Okay, next matter.
Item number 4.
Yes.
Item number 4, supplementary list.
Lordship, the matter is, it is represents file in 2019. Here the petitioner being aggrieved with the illegality committed by the 6 private respondents in the schemes. It is called VSE, implementation of the schemes. So now what I feel, the Lordship, if I may be allowed to approach the BDO again by filing a detailed representations, and he will consider my representations.
For works that you were carried out which year, Mr. Kurish?
It's 2018.
1819, madam.
Para 5.
In fact, my lord, by now the work must have been completed because we have given our report at the time of enclosing our affidavit in opposition. My lord, most of the work were.
So we want to file a representation to the work.
You're talking about work done by these by this 100 days program, right?
Yes. There is some financial irregularities, and it was not executed as per the work order.
Now you think that after now sitting like 4 years or 5 years hence,
5 years plus.
you go and see the work that has been done, you'll find naturally the work what has been done and damage would already been done, also wear and tear.
So we just want to file a representation to the number 4, Broad Department officers.
My lord, there is a question of utilization certificate, why it was not
Where is
issued,
that?
my lord. To that, my lord, we have said that since the work at that time, my lord.
So see, you can't just satisfy your own egos.
So now
just
it must have been given
Where's the
to
affidavit?
concerned, my lord. At para 6 of the writ petition, my lord. There's a question of not issuing of utilization certificate.
Mary Lisa Marak.
Yes.
My lord, yes. In the writ petition, para 6, my lord, the question has been raised and we have replied to that, my lord, in para 11 of our affidavit in opposition.
Second. You will dispose it of.
I know, yes, dispose of some.
Oh, yes. Where's the reply? Para?
The reply is in my affidavit in opposition at para 11, my lord. We have stated that since the work was still under progress at that time, my lord, when the writ was pending.
Yeah.
So, my lord,
Well, you see it's been filed now.
my lord, it should be completed, my lord, because there is a time period given, my lord.
Yes, sir, take down. The petitioner before this court. Who are you?
I'm the petitioners because I am also affected by the construction made by them, which I have stated in the writ petitions.
Well, there is a private dispute between the petitioner and the private respondents, and there's a
It is very apparent. They filed, he filed FIR, he filed counter FIR.
In para 3 of my petitions, I stated the petitioner being the residents of the Tahsildar Para.
Okay, right. Yes, the writ petitioner is before this court by way of the instant writ application, complaining that the respondent number 6, that is the secretary of the Village Employment Council of Tosil, TOSIL, DRPRA, Tosil Para, has misused the funds of schemes under the MGNRES for implementation of developmental work stuff. The petitioner, it appears, had also filed an application on 12 October 2018 to obtain under the RTI Act 2005 to obtain information about the work orders issued and amounts sanctioned as well as utilized. Stop. Next paragraph. From the materials and from the pleadings, it appears that the information was supplied to the writ petitioner, and also that there were antecedent proceedings which involved private disputes with the respondent number 6, number 6 and his family. Next paragraph, wherein criminal cases have been filed against each other. Stop.
It will be 6 and 7, madam.
6 and 7. Because file these other stop. Next paragraph. Mr. M.F. Kurishila, counsel for the petitioner, as state submits that as the projects concern the years 2017-18 or 18-19, he may be permitted at this stage to file a representation before the respondent number, BDO's whom? 4 to obtain necessary information with regard to utilization of funds. Next para MS R. Kulni, counsel for the respondent number 4, submits that the work has since been completed, and furthermore, no specific statements have been made in the petition with regard to no materials have been placed by the petitioner to substantiate his allegations.
They say that I have not approached them. They saying that I have not approached.
No, my lord.
In
para 12,
I have placed. What do you have to say, Mr. Hinyota? Anything? Nothing. Mr. Dinyota, for
they have filed a representation to which an inquiry was conducted, and the inquiry shows that the bogus work has been implemented.
It is further submitted by MS Alkoni that in the affidavit itself,
in para 12, madam.
at para 12, it has been stated that verification has been done. An inquiry report was also submitted, which showed that the works had been executed as per the estimate.
No, it is not executed, it's going on.
As per estimate, anyway.
It was going
Next
on.
paragraph, Mr. D. Nyota for response. Well, we'll close these matters. Nyota for respondent number 6 and 7. 7 submits that at this stage. Submits that he has no submissions to make. Next paragraph. This court has heard the counsel of the parties and examined the materials on record. Start. A perusal of the writ petition itself. A perusal of the prayer behind the petition itself shows that the petitioner is seeking directions to take action against respondent number 6 if the fund sanction is misused, and further to quash the FIR files against the petitioner by respondent number 7. Stop. A further perusal of the statements made in the petition to disclose any concrete materials that we brought to this court to support the submissions of the Net Council with regard to the misuse of the funds as alleged. Further, the prayer also being based on being based on contingent issues, so does not deserve consideration, as also the added prayer to quash the FIR. There being no merit in said petitions, the same as Akoni's dismissed this. You can do whatever you want. You can initiate fresh FIRs against them.
Just to approach the
Madam, the case is at the verge of completion evidence.
No. Yes.
Yes, no, that will be concluded, madam.
5.
So 5 minutes more. Five minutes. It's too much. Yes, Mr. P.G. Sangma.
This matter was taken up on Tuesday, my lord, where Lordship has, on the previous occasion, has directed Mr. Bhattacharjee is appearing for the state to submit a report, my lord. Mr. Bhattacharjee is on legs before the other court, and my lord.
What report?
A report was.
Report, inquiry
report, my lord.
Regarding termination of the petitioner.
There is a direct.
Ah, yes.
So, my lord, my humble submission is Mr. Bhattacharjee is before the other court. He's still having his matter.
After some time?
And he has informed that, my lord, there's a change of officer.
There's a?
So therefore, there's a delay in getting the report, my lord. If Lordship can kindly give us some time, my lord, a week or 2 months.
Okay, MS Arcoli submits that
2 weeks, my
the
lord.
required report. That's the last order.
My lord, the last order was on the 11th.
See, last time so you appeared.
My lord, I appeared,
That's
Mr.
a substitute
Bhattacharjee was
replaced. And who the appeals matter? S. Bhattacharjee or Kim?
Private respondent.
The last occasion, Bhattacharjee appeared, and
I
then
appear for the state, my lord, on behalf of
after
Mr.
that,
Bhattacharjee.
Yes, by order dated 28/3/2023, this court had directed the learned GA to produce the records of the inquiry stated to have been conducted by the block mission coordinator as reflected in the letter dated 8/8/2019. Stop. Today, Mr. MS Arcoli submits that the said records have not been received as there has been a change in the incumbent of the office of the block mission coordinator. Accordingly, 2 weeks' time further granted for production of the records.
Must bless Lordship.
Main list, item 27.
Yeah, what is this?
Yes, my lord, I'll quickly take my lord through the facts, the sequence of events. My lord, the petitioner had purchased a plot of land from the respondent number 11.
Is he here?
This one.
Lordship, so far as state is concerned, I'm here, Your Lordship, for
We understand that, we can see you. What about the other respondent?
Then this consul also is there, Mr. Kanta. He's not seen in the.
Okay, just yes.
Yes. So, my lord, I'll just go through some of the essential sequence of events. Now, if my lord may kindly come to page 29 of the writ petition. So, a sale deed was executed, and on the basis of this sale deed, I was granted a pata. That is at page number 38. I hope my lord has that.
Yes.
Then the respondent number 10 files a complaint before the sub-registrar's office. That's at page 54. My
This is
But let me explain. Respondent number 10 and respondent number 11 are cousins.
Okay.
Both claiming to be owners of the plot of land. Now, then the petitioner then out of nowhere receives a summons. That's at page 59. And I'll just read out the summons. With this notice, I would like to inform you to come and appear before the undersigned to give an answer with regards to the land of Srimati Akrisha Milliam Pada, situated at so-and-so, per order enclosed so-and-so.
Yes.
Date of order. My lord has that?
Yes.
And next with this order is at page 60. There's an order. Notice to be issued to Mr. So-and-so to show cause in person before the inquiry as to why criminal action should not be recommended for the illegalities and criminal acts relating to the landowner so-and-so.
Yeah.
Right? And then, my lord, kindly come to page 61. 62. So this is the communication with reference to the subject cited above. The office of the acting CM Hema Milliam is pleased to send to you, the Khasi Hills Autonomous District Council Shillong, the decision for your information and necessary action. And the decision is on the next page. At page 64, that's the translation. Yes. At paragraph 3, that before issuance of land ownership to the actual owner, the two numbers of pattas which have been issued earlier and the details of which are mentioned here and below are required to be cancelled.
Yes.
So the two pattas are cancelled. My patta is cancelled and my predecessor in interest patta is also.
Is he here before the court?
He
will be the party?
Respondent number 11.
The earlier
yes,
owner.
Yes. But I don't know who's appearing for.
I'm appearing lordship for respondent number 11.
So
let's see your prayer.
My prayer. My prayer is at page 20.
From 19.
From 19.
From 19.
So 1920 and
to set aside quash this number 7.
Yeah, the executive order. And to say and D is to set aside and quash the document entitled so and so, meaning deed of confirming land ownership to the respondent number 10.
But this is purely a civil dispute, except the cancellation of patta, that's all.
Yes, that is
asking for.
that is
a quite document title. This is deed confirming land ownership. That how will it figure in the proceeding 226? You can understand if like there's been some action where some land document cancelled out hearing you, something like that.
Yes.
We can confine it to that. But then these prayers here are totally,
Yes, my lord, that's precisely my point.
Yes.
See, my patta has been cancelled. And before the cancellation of my patta, one notice is sent to me. And the notice does not even spell what my presence is required for. The thing is, natural justice entitles a person to claim as a right notice of the place, time, and the case that he has to meet. But in my case, my lord, may I kindly come to page. Yes, page 59. I've shown this to my lord before also, but
yes, it's the notice.
The summons in a notice. Now, if my lord, rest of a reasonable man, if someone received a notice like this for the first time, would he know what kind of case he is to meet? And
these proceedings are taken by executive committee.
Yes.
Who's for the council?
Mr. Gantaya was.
Where is he?
He's not. He was busy. He was on busy, and then he disappeared all of a sudden.
So these proceedings were taken by the district council.
Yes.
And what are other parallel proceedings before the CMO Millim?
Yes, my lord.
The other parallel proceedings, because he cancelled the patta, correct?
Right.
Or was it cancelled at the directions of the district council?
No, the respondent number 8 cancelled the patta.
Right. I mean, were they independent proceedings or they were from the same proceedings of which where summons had been issued to you?
My lord, that's what I'm not aware of. Because I get this summons from nowhere, then I'm later informed that my patta has been cancelled.
No, who's that inquiry officer was appointed under what?
authority?
Lordship, in my humble and respectful submission, everything here, Your Lordship, the claim of all these parties, Your Lordship, these are not sustainable, Your Lordship. Whatever the district council or the same of Milliam had exercised their jurisdiction, this is an illegal exercise of jurisdiction, Your Lordship, because the parties here, they are claiming of a land, Your Lordship. This is a government protected land, Your Lordship, like compartment 6, Your Lordship. And the same of Milliam is fully aware of that, Your Lordship. We have issued a letter to him to say that why you have issued a pata in favor of some private people when you know fully well that this is a government protected area.
Now, only one thing, yes, just let this court try come to grips. How do you come to own the property? This is number 11. On what basis do you claim that you transferred the land? On what on your titles? On what basis?
Lordship, it was from my mother was she was the inheritor, Lordship, and
How do you inherit? You're a male.
Lordship, by the gift deed, Lordship. She had
The basis of how can she gift it is clan property.
Because
How will this person come in? He's a male, and on what basis is he alienating this property? You've taken advantage and made some money from unsuspecting consumers. I mean purchasers.
No, Lordship, the entire thing was even the gift deeds and all, Lordship, that which was made also, Lordship. There are some signatures that has to be verified, Lordship.
No. Who? How? Let's go to the base to the entire genesis of this matter. You have entered into a sale with the petitioner, correct?
Yes, Lordship.
On what basis have you alienated the land?
Lordship, which is this is with that after receiving this gift deed, Lordship, which is an extra one. Lordship.
I think he should be put in prison. There's a gift deed. Who is this person? Number 11.
He's the respondent number 10's cousin.
He's the brother of R10, Your Lordship.
No, cousin.
Who's Akrisha Milimpada? Who's here? She claims the same property.
She claimed, Your Lordship. She claimed to be the property.
Okay, maybe she might have some claim she is a female to the lineage. But who's he to sell? We'll ask you to compensate him for whatever losses he's incurred.
Lordship, that has to be because Lordship,
That has to be. That means you accept a position that you have to compensate him adequately.
I am not accepting that because
It's a peculiar position. Now, let me explain. Now,
No, I don't know explanations. Only I want to first come together. How, in the first place, this entire transaction commenced? If you say that it comes from 11, who is a male, Milimpada, whatever, where's your document of title from which you derive your title and for which you transacted the sale deed? The sale deed, Annexure 4, page 29. Where's the document of title?
They don't have anything, Your Lordship.
Now, what is the deed of declaration which is unregistered? Is on the basis of this?
Yes, Lordship.
No, my lord, kindly have
Yes,
page.
okay, yes. Please, yes. What do you have to say? Submit. It's just that this is came to mind of the court. But if what Mr. Shulai says correct, we have to examine whether the person had any, notwithstanding whatever,
If Lordship,
channel
for
2
the
to
time
6.
moment, for a moment, if Your Lordship is pleased to come to the writ petition at page 54, Your Lordship.
It's very strange
Page
kind of,
54, Your
very
Lordship.
strange kind of.
Page 54, Your Lordship. This is the representation submitted by the R10, Your Lordship. By R10, respondent number 10, the Akrisha Melimpra, Your Lordship, to the sub-registrar. Lordship, I'll take Your Lordship to page 55 at paragraph F, Your Lordship. F and G, Your Lordship. 55, Your Lordship, paragraph F and G, Your Lordship. May I read it, Your Lordship?
Oh.
May I read it, Your Lordship? Lordship is aware of no cloud plan, Your Lordship, that full bench decision, Your Lordship. That we have taken the plea in our affidavit.
Now, it's one with 10's opinion, it's one with 10. Number 10 whom?
Number 10 is the one who has actually inherited this property.
No, but how she inherit this property? Now you say that according to this document, 15,000 square feet is actually belongs to number 11. And 156 acres belong to you.
That's a dispute, man. That's what we are disputing. We are saying that we are the innovator, not the respondent number 11. By fraud, he has made the deed.
Then have you filed FIR against him?
FIR has been filed.
Then where does it leave the petitioner?
Objection has been put.
Yes, my lord.
Where do you leave the petitioner then?
Look,
So what are you trying to, by this writ petition, what are you trying to achieve?
That FIR or the police complaint that they're talking about.
That's besides the point.
No, because
What do you seek now through the writ petition?
The thing is that, my lord, if I was issued the patta, and if you're going to cancel my patta, do it in due process. Hear me out first. Because that I can claim as a matter of right. That's my
No, that's okay. I mean,
Right.
what other thing? You're asking for, according to your prayer. Your prayers are, you've seen your prayer.
No, but that executive order has to go.
No, you've seen the prayer.
Yes, I'm saying.
It's not a question has to go. Have you seen the prayer regarding to set aside the deed of, what is this?
I know. That's a little ambitious, my lord. I understand.
To set us come to prayer C, okay? To set aside and quash the executive order, so and so of the respondent number 8 names M. William Darbar get ownership of the said plot of plan, in respect thereof. Set aside and quash the document titled duly written stamp and down, meaning deed from land ownership bearing, so whereby respondent number 8 has confirmed ownership of respondent number 10.
My lord, all these can be withdrawn.
To direct respondents not to interfere in possession. To direct respondents not to deal with any person other than the petitioner with regard to such.
I understand, my lord. So these...
My lord, if I may, there's already a civil suit pending between the petitioner and the respondent number 11. I don't know whether my friends...
Then you take your, do you have to find remedies there? Even for declaration that this...
There's already a civil suit pending, my lord, before the district council.
Who's the appearance in William?
I will pay.
You have anything to say, Mr. Genji? With regard to the proceedings, the patta was cancelled after hearing both sides.
It was on the basis of inquiry of the district council, my lord.
No, the inquiry was conducted, but were they in the knowledge that a certain inquiry was being conducted?
Yes, yes.
They were aware of it.
They were aware, very much aware.
They took part in the inquiry.
Notice
was issued, but it didn't come again.
Where's the inquiry report? Has been filed by affidavit.
Yes, it's filed. Yes,
Where is it?
Page 143 of the joint of the affidavit filed by the respondent number 10 mega.
Page
143 in the affidavit filed by the respondent number 10 mega. 143. Next to 27 mega.
One second. What's an order? Where's the inquiry? This order is impugned. Where's the inquiry? Inquiry report.
Page 131, my lord.
131.
Please start 131.
Starts from
Page 131.
Yes, my lord. And lecture 21. To the inquiry officer, start from that, my lord. Comment from that. and then the scissor
Okay.
copy.
Yes. Who were the people who took policy? After proper inquiry or documents from both the parties.
131, my lord. Very in my lord.
No, just 1 second. I just want to see whether there is any indication that the petitioner was aware of these proceedings and whether he had participated, that's all.
127, page 127, correction 24.
I don't want to confound or confusion, yes. Huh? Page?
127.
Okay. Your name, I'm sorry, I didn't get your name.
Sir, my name is Laludem Sanga.
Lalem Sanga.
Yes.
Yes. You've seen this 127?
My lord, I don't seem to be able to locate the page.
127.
We need the district council also here. Because inquiry, it seems, was.
In the affidavit filed by the respondent number 10, my lord.
What are notices received, Mr. Kinching, by all the people concerned here? That is Akrisha, Milimpada, Hira Milimpada, Dipen, Mohan Roy, Dikwa Mukim. They all received. They all received.
They are received.
Speed was kept in the dark, Your Lordship.
Anyway, they have received, my lord.
How do you expect the court to go forward and, like, this kind of. We just have to. Now, where's the inquiry report, Mr. Kinching? 131.
It is on page
132.
my lord. Analysis and finding. 132. A brief report on the matter relating to the landed property situated at Lightgore, Nong Dandeng, East Kashmir. After proper inquiry and careful perusal of all the documents and from both the parties, the following findings are reached. The findings also have been given manner, and all those documents have been dealt with.
1903, 1910. A court, you've managed to confuse the court totally. Yes, continue.
Yes, my lord. So, the document we just read, it is not reflective of any inquiry or application of the mind.
It is very much there. We have asked them to come.
However, so our documents of Sri Hiram to indicate the boundaries area as follows. Also, was that we are going to see only the measurements of the corridor boundaries and area of land and refusal to accept notice by Sri Dukam Mukim shows he does not respect the Darbar summons office of CM of Mamilem. Then it will examine the 2016 agreement, objection to acting AM, so proceedings with regard to meeting held in the presence of the CM, so office bearers and relatives presumably referred under certain, and no other person. Is a mistake. Okay.
And 135 is a finding, my lord.
Yes.
The perusal of all the documents, the finding are as follows.
So this report submitted to the district council.
Council, my lord.
Yes.
And on the basis
and
of
the
this
council,
report-
what was the order of the council? What was the action taken on the basis of inquiry report?
143, my lord. 143.
Okay, right.
So we said the report 24 October 2018 and
yes,
and the order is here, my lord. In view of the finding of the acting Chairman Darbar by the said inquiry conducted by the
where is reading?
From 143, my lord.
140, yes. In view, where is that reading? Okay, second last one. This is fact axiom.
Of course,
Okay, that's one part. Now now as per inquiry, you should notice they never bothered to come.
They never bothered to
finish
come.
your inquiry, and you found out this respondent number 10. 10
Yes.
is the rightful. Okay.
Yes.
Now, what does the government come in here?
Government is not aware of all this proceeding, Your Lordship. These are proceeding done behind the back of the government, Your
No,
Lordship.
I
These are
mean, what is your
illegal
case here before this
proceeding.
court?
Our case, Your Lordship.
So, how you were made party?
Lordship, when they challenge all this, then they made the state they still as respondent, Your Lordship. Then we file our affidavit, Your Lordship, because you know that this is a government protected land, Your Lordship. It's fall under compartment 6.
Where is the affidavit?
Lordship will tell me first, Lordship, I'll take to the page 55 of that writ petition. Page 55, Your Lordship.
Because your claims are limited to that you're not heard before the scandal. That's it. Okay. Yes.
Lordship, kindly come again to page 54, Annex 11. This is the representation, the objection filed by respondent number 10, Your Lordship. Lordship, I'll take Lordship to page 55 at paragraph F.
Page 55 of the writ petition.
Writ petition, Lordship, yes.
Annex 11.
Lordship, yes.
Where's para 10 here? There's no para 10.
Kindly come to paragraph F, Your Lordship. According to my land documents, Lordship has got it.
Yes.
Internal page 2 of that objection, Your Lordship.
Yes.
May I read it, Your Lordship?
Yes, yes.
According to my land documents, the boundary
One
and
second.
the total area are true and correct since the
Yes.
Year 1965 are still the same till date, which are as follows. Then, Lordship, kindly see the boundaries which has been mentioned above as per the land document right from the time of the British government agreement for lease dated 2nd December 1874. The square feet are still on the same, and the landed property inherited. So then, Lordship, G, I would mention here, Your Lordship. So, Your Lordship, it is the admitted position, Your Lordship, that there are R10, Your Lordship. R10 also, Your Lordship, admitted that this land was leased to Her Majesty the Queen of England, Your Lordship, those days in the year 1984, in the year 1874, Your Lordship. So, Your Lordship,
No, one thing, leased by whom? The three clans at least.
Lordship, then I'll take, Your Lordship, to the affidavit filed by the state.
Let's see affidavit.
Lordship, kindly come to page 16, Annex 1. Your Lordship, it is not readable, and the type copy is at page 17.
1 second.
Lordship, I'm sorry.
Your affidavit is?
This is filed by respondent number 1, 2, and 3, Your Lordship.
Okay, this is, okay.
Lordship, this was filed on 6/3/2019. Lordship, kindly come to page 16, Annex 1. The type copy is at page 17. Lordship has got a document. May I read it, Your Lordship? Know all men by this present, I, Ukhar Melipra of Nongkrum, son of Uchai Ilaka Nongkrum Khasil, the proprietor of land situated at Wa Dingling, in the state of Khairim, and bounded as follows, Your Lordship, do hereby lease the said property in perpetuity. Kindly see, Your Lordship, in perpetuity to the British government in consideration payment of rental of 50 a year so and so, payable early in the advance, and I declare that this list shall be binding on my heirs, successor, or assigned in virtue thereof. I so and so do hereby set my hand and seal this second day of so and so in the presence of the subscriber. So this land, your lordship, claimed by the parties, your lordship, this was leased, your lordship, to Her Majesty the Queen of England.
Same is 874.
Your lordship, yes. 1874, your lordship, yes. 1874, your lordship. And this also, your lordship, the acting CM of Millennium, your lordship, the respondent is fully aware, your lordship. Your lordship, kindly come to page 18 of the affidavit. And when he conducted the inquiry in 2018, your lordship, he did not give notice to the state government. Lordship, kindly see, this is the letter dated 22nd March 2015, your lordship. I may be allowed to read, your lordship. Sir, to the SM of Millennium Mohar, subject issue of Pata, sir, in referring to this subject, I am enclosing with a Pata issued to Shri Hero Ban Nista Milimpda, Lightcore Milimpda, duly signed by you, dated so and so. The land issued by you is a part of Lightcore Government Protected Forest Compartment 6. So the same of Millennium is aware, your lordship, that this land does not belong to any private individual. It belongs to the government. Then lordship, kindly see page 19, your lordship, annexure. Then what happened, your lordship?
19.
Then they have submitted to the Air Force, your lordship.
This is dated when?
This is lordship.
October 16.
No, has been received.
5th October 2016.
Lordship, yes.
Who's still Le Pen?
Somebody is there, your lordship, to with intention to hand over this land, your lordship, to the Air Force. Then what happened, your lordship? Then lordship, can you come to page 21, annex 4? Then the divisional forest officer, what did he do, your lordship? He addressed a letter to the wing commander. In reference to the above, I am to inform you that the land in question is part of Lightcore Protected Forest Compartment 6.
No, but the thing is that where there's no mention of what pata number or what pata is this?
Lordship, yes.
How do you say that this is the same pata?
Submitted by Lee Pen, your lordship. Claim that document it belongs to him.
Lee Pen means that ex-Chinese premier.
Yeah.
Anything else?
Then lordship, if lordship is, can you come to the affidavit, your lordship? We filed the affidavit, your lordship. We are, if lordship is pleased to come to eternal page 3 at paragraph 4 of our affidavit, your lordship, we have referred, your lordship, to the full bench decision of the Rapsila case, your lordship. I need not, lordship is fully aware of that judgment, your lordship.
Okay, heard, judgment reserved.
What?
My lord, I would like to refer only one thing, madam. It's not a question that they were kept in the dark. If you go through the respondent number 10 affidavit in page 171, madam, it is very much there that the government is fully aware. This is the letter of the BDO of Millennium C&D.
Yeah, we'll pass on this.
Just one point.
Yes.
My lord, in a writ court, I will respectfully remind my lord that we should not wade into competing facts and competing claims. And my only thing is that just grant me the satisfaction of being heard. That's all. They may reject me. Because let me at least gain my reputation back. That's all. Because now I look like a fraudster.
You're not a fraudster. No, you've been defrauded.
No, because
you've been defrauded. The person has been defrauded. It's not that they've been defrauded. That's the thing. Some orders have to come from the court. Yes.
30.
Yes.
Highly apply, your lord.
Yes, Mr. Abbas, you ready?
Lordship, regarding this expiry order passed by the tribunal, and they have come against the order of the tribunal. So, Lordship, Lordship permits, and I will just do a citation, one citation regarding similar case in the Supreme Court. So, it permits to just refer that citation. 2001-6 Supreme Court 569 Punjab National
SEC
Bank.
or SEC or AR?
SEC.
Page?
Page 569.
Yes.
Punjab National Bank appellant versus O.C. Krishnan and others.
Okay. This again Punjab National Bank, this one also?
Your Lordship.
So, Your Lordship, I just refer para 5 and 6.
IDBI Bank.
Yes.
Para 5 and 6 only, Lordship, available.
This is, they're well aware, this is all strategy for them. They're well aware of the law. It's not a question of them being approaching.
Your Lordship, this matter will come up on Tuesday. Mr. Paul is on next before the Honorable Supreme Court. So, for that reason,
Okay, we'll take it on Tuesday.
Lordship, we will come after 2 weeks because next week I am going to Delhi, Lordship, some family.
Mr. Upadhyay is there?
Bank is that I am just panel editor of the bank. So if my name is not there, so they will not sanction the bill.
Okay, after 2 weeks. Yes. Due to the absence of Mr. K. Paul.
32.
Please, Your Lordship. Lordship, here I am challenging the gradation list, Mano. Lordship, what has happened in this matter, in the pendency of the matter, my lord, an affidavit and opposition was filed by the state respondent. And after the result of the affidavit in opposition, my lord, we made respond number 5, 6, and 7 as a party in the instant case, my lord.
Yes.
So, after that, my lord, notice was served upon them, but none appeared. So, ex-party proceeding was initiated against them. So, thereafter, the matter was pending. And later on, it transpired that the department, my lord, during the pendency of the matter, had issued a draft gradation list.
Which department?
This is Commerce and Industries, ma'am.
Mr. Judge, appearing for whom?
Private respondents 5, 6, and 7, madam.
But it's gone ex parte against
it has gone ex parte. It has gone ex parte, but law is very clear, my lord, I can still participate.
You're not filing for setting aside ex parte order?
I would humbly submit. That's not required at the moment. Law is on my side on that limited point.
How do you see laws on your side?
Can I place the judgment, my lord?
Yes.
Lordship, I refer to 1955, AIR 1955, SC 425, my lord.
What does it say?
Lordship, it's a 3-bench judgment. The import of this judgment, without going into specific paragraphs, import is that even if there is an ex parte order against me, the day I appear in the proceedings, I can participate from that day henceforth. But if I want to rewind the clock, in that case, I have to get the ex parte order set aside. So, in other words, for example,
by your estimate, that means you don't need to rewind the clock at all.
Because
whatever transpired before this court, I mean, in
yes.
proceedings before the, I mean, whatever happened the case before, including your situation.
Yes, my lord.
Nothing needs to be changed.
It doesn't, in my humble submission, for the reason that, and my friend will agree with me on this, for the reason that initially when the writ petition was filed, there was absolutely no averment or prayer also against 5, 6, and 7. Because of that, 5, 6, and 7, in their wisdom, thought it not necessary to participate in the matter. Matter rightly went ex parte against them at that stage, my lord. Now we suddenly find that there is a fresh cause of action to keep an infructuous matter alive. Now there is a parallel, I would say almost a parallel proceeding being drawn up against 5, 6, and 7. Now relief is being sought suddenly against 5, 6, and 7. So, therefore, my lord, it becomes necessary for me to participate. Law says from this stage onwards, my lord, I can participate. So, what has gone before has gone. I have no axe to grind against that, my lord. There was no prayer against me. So, I have nothing in respect of that previously happened proceeding, my lord. But now they want certain reliefs against gradation list, which affects me.
the matter revolve around the rule, my lord, the interpretation of a rule, my lord. My entire case hinges on that particular rule, my lord.
In fact, even before that,
if that rule is cleared off by this honorable court, my lord.
Cleared off meaning?
Like interpretation in a proper manner, because what the state government is trying to portray, my lord, by reading that particular rule, my lord, is saying that merit list will prevail, but clearly states, my lord, that it will be date of appointment has to be considered, my lord.
My lord, before going into this aspect, I would humbly request this honorable court kindly consider whether the
We have not started the hearing.
the miscase,
I'm just noting down the orders which he has impugned here. That's the only thing.
Yes, my
That
lord.
is one is 31/7/2014 to see how relevant they are.
Yes, my lord.
as of now.
In fact,
19/5/2017 and what is the 10/3/2021.
In fact, my lord, on the same line, if lordship looks at the prayer of the original writ petition,
10/3, okay. 10/3/2021. Why are you impugning this staff gradation list? Comments represent a draft, if any, should be submitted 30 days. Then you impugn the draft is also okay. Then the next one is 31/7/14.
Please, Your Lordship. Lordship, before we proceed further, and this miscase 20 of 2023, filed on 22 March 2023. I'm afraid, Your Lordship, in this application, they are making a prayer for staying the draft gradation order of 9/2/2023.
the miscase
Nine-
itself is
miscase
not maintainable.
itself.
It's not maintainable.
Lordship, I just want to bring to the notice of the court.
And that goes outside the scope of this writ petition.
Absolutely. So they should have brought by virtue an amendment and amend the main writ petition.
Now what happened?
No, during the pendency of the matter, they suddenly came up with this draft gradation list, my lord. Knowing very well that the matter is still pending before this honorable
that
court.
situation,
So they're
They
trying
have no orders
to derail the
preventing
entire proceeding of this honorable court, my lord, by bringing up with a new draft gradation list. If that be the
Okay,
case,
yes.
then
What are your submissions on the case? What is the problem? What is your issue?
my main issue
Now the
is in the
now you
interpretation.
impugned 31/7/2014 seems to be some sort of seniority also. This is an order by or letter seniority LDAs and the Directorate of Commerce Industries. Just go from here, start from here. What you agree as appears in the merit list, the junior number so what you are?
My grievance is, my lord, that I have been appointed initially prior to respond number 4, 5, and 6. So far as respond number 4 is concerned, my lord, I'm not my grievance not to me, my lord, no longer stands because they have already taken voluntary retirement.
Yeah.
But in respect of respond number 5, 6, and 7, my lord, now the entire thing hinges on the rule, my lord. If the rule is in my favor, my lord, then I'll be senior to the private respond number 5, 6, and 7, my lord. So, if lordship wants me to come with a sequence of
Yeah, I was just because I was not really hearing you all. I was just examining the impugned orders because since they're of a certain vintage, you can say 14, 17. That's why you're examining. Yes.
So, my lord,
if that cause will suffice.
If lordship comes to annexure 4, page 20, my lord.
Okay.
This is my appointment order, my lord. I've been appointed.
Okay.
Thereafter, my lord, a draft gradation list was published in the year 2010. That is 4th May of annexure 6, page 23. My lord.
Page 23. The first gradation list.
This is the first gradation list, my lord. Here, private respond number 4, who was a promotee, my lord, was given promotion, was given seniority ahead of the petitioner and private respond number 5, 6, and 7. Kindly come to page 24, my lord. If lordship sees serial number 22,
yes,
this is the private respond number 4.
Okay.
And I'm at serial number 30, my lord.
Okay.
And the private respondent falls below me, that is 32, 33, and 34, my lord.
Okay, ML Sumer.
Lordship. So
they are promotees.
No, we are direct recruitees.
No, this below you, the others ponds are promotees.
No, they are not promotees. They are also.
They
have also come out from the completed examination.
Same exam with you.
Same exam.
Okay.
Then what has transpired, my lord? Then the representation was filed by a number of.
Now you are senior. You were placed above them.
Yeah, I was placed above them.
Okay. Yes.
So a representation was filed saying that I should be above the promotee as well, because Rule 29, Sub-Rule 4 is very much clear.
This is Annexure 7.
This is Annexure 8, my lord, page.
No, what's
Annexure 7, my lord, yes.
Okay,
page 28. Thereafter, my lord.
1 second. Okay.
Thereafter, my lord, they publish a new. Did you publish a new gradation list, my lord? At Annexure 8, page 28, my lord.
Yes.
Now this is the correct position, my lord. Page 29, serial number 28.
Now this first one, 2007, this earlier was a draft gradation list, correct?
Yes, my lord. The earlier one was the draft gradation list. This one is the republished list, my lord. This is the new republished list. So, Lordship will find page 29. I'm serial number 28, my lord. This is the petitioner.
Okay.
Then comes serial number 31. This is the private respond number 4.
Yes.
Then comes respond number 5, 6, and 7.
Okay.
This is the correct position. Then after that, they published another draft gradation list, my lord. Page 9. Okay, Annexure 9, page 31, my lord. Lordship will find page 32. This is also the correct gradation. Lordship will find the petitioner at serial number 23.
Okay.
Then respondent number 4, Lordship, serial number 26.
27, 28.
27, 28, 29 with private respond number 5, 6, and 7.
Okay.
Thereafter, another gradation list was published in the year 2013, my lord. Sorry. 2014, my lord. Annexure 10, page 38.
What about Annexure 9?
This is the type copy, man. This is just the page 34, 35, 36. This is the type copy.
Annexure 10.
Yeah, Annexure 10 is the gradation list, man. Here again, my lord, they have changed the seniority again. Page 39. Now, respond number 4 is placed at serial number 23.
Yes.
Respond number 5, 6, and 7 at 24, 25, 26. And the petitioner is placed below respond number 6
at 27.
Page 27.
No, at page at
Being agreed by this, a representation was filed at page 41, Annexure 11.
Yes.
Thereafter, my lord.
What was the reply?
The reply is at Annexure 12, page 43.
That's your first impugned order.
Yes.
Oh no. Yes, first impugned. Yes. Read it.
With reference to the letter number so, a correction of the draft gradation list has been done according to merit lists issued by MPSC as instructed by your letter number such and such. As appears in the merit list, the junior serial number 68 KT Sangma was allotted first from SAD on 17/5/2007, while the senior serial number 42 Srimati so-and-so was allotted on 14/6/2007. Srimati H. Nongsich and Srimati Y. Skutga on 22/8/2007 at serial 58. ML Sumer on 27/9/2007. They were appointed later, my lord. If you just see that. So regarding seniority between the promotees from typists and direct recruitment, that is in respect of respond number 4. For gradation list, the date of appointment for the juniors, there is serial number 27 who ranks in the merit list as under of the promotees number 22 and 23, 16/7/2007, while the seniors ranking 42, 43, 55 and 58 were 29/6/2007, 4/9/2007, 27/9/2007 respectively. Under sub clause B of sub-rule I of clause D of sub-rule 4 of rule 49 of the service rules of 2010, the intese seniority shall be in orders of the name appear in the merit list of the MPSC, and further in between LDAs shall be according to the dates of appointment. They themselves in the order has reflected that it should be from the date of appointment.
Very confusing. I think Mr. Khan, you have to.
No, they are actually trying to make it confusing, my lord.
Decipher it, It's
no, actually, they're trying to make it confusing so that they can.
No. See, the thing is that now they want to go back to the merits of MPSC from the time you did the exam by recruitment.
That also, I'll come to that aspect, my lord. I'll come to that aspect, my lord. If lordship comes to that aspect, lordship will be very much clear.
No, the thing is that, see, what happens is that if you apply the revision policy, sometimes in the merit list, like those who are more meritorious will not be given appointment immediately.
Yes.
Is this that case here also?
Yeah, but
then they appoint subsequently.
Yes.
But then when they recalibrate the gradation list, then as per merit, say okay, since they are the merit list.
Yes. That is exactly the same case, my lord. But what has happened? They are trying to take the aid of office memorandum of 2009, which lordship will agree. It was set aside by the division bench, my lord. That particular office memorandum. So now they have no legs to stand, my lord, on that particular office memorandum. It has been set aside, my lord. So now the entire thing hinges on the particular rule only.
Where's that rule?
Just please, my lord.
I think we have it another day. Just let me just look at it first.
Then I'll just place the rule.
You just place the rule. Mr. Khan, you assess the court here.
Lordship, another important aspect is that process system has been made retrospectively.
So, but that has no bearing in this matter, my lord.
That does not go there.
That will have to have a bearing, Lordship, for the simple reason that we have a very two interesting situation here. The list prepared by MPSA, and that is based on merit. And second is the component of date of appointment. My Lordship, at least the list, the merit of MPSC, Lordship is absolutely aware that from that list, even if you don't apply the roster system, but in this case, maybe that will have an effect because it is retrospectively. So from that merit list, the component of 40 Khasi Jayantiya, 40 Garo, and the rest applicability, Lordship. Whether that system was followed here or not.
No, we can't go there.
We can't go there. Understanding, my lord. I don't think roster system is.
See, I don't think roster will come here at all because whatever appointments they have got appointed. It's not a question of only one section being appointed and that you're going to apply like this. Then we can't go there. Now the only thing which this court is aware is that look, in certain cases of this seniority list, what happens is that suppose there's a candidate from the Garo category, okay, and at that point of time. Suppose the 10 posts, right?
Yes.
Now, like they are in the merit list, like the 8 who come on top, okay, Khasi Jayantiya category, and then below that there are 5 or 4 who are from the Garo category who qualify also. Now you apply that 40-40, so 4 from the top will get and 4 all the Garo candidates will go, right? So that the remaining 4. Although they are more meritorious than the Garo candidates, they are still not appointed. And so maybe they accommodate later on. And so when they come at that point of time, when they try to recalibrate the credential, they say, oh, we'll go as per MPSC merit list. And so they recalculate on and place these people on top. Whereas, like the Garo candidates, they've been appointed prior to that. So where do you balance that entire equation?
Lordship
That's the only thing.
absolutely diagnose the issue.
Yes.
Yes, Lordship is very
So
good.
that's what happens.
That's what happens. Absolutely correct.
Lordship, if you can
Lordship,
kindly bear with me and come to the affidavit in opposition which they have filed. For the
No,
state.
just only that I want you to assess the court because this I think there has been another decision of this court in this similar kind of case. I'm not.
Lordship.
Yes.
It's by this bench.
I'm not sure about that, but
Why?
I have.
By the division
I have.
bench,
I have a
Lordship is the same case. My learned friend is relying on the.
Oh no! I appeared as a counsel, I think, in one of these matters, not as a judge. Right.
Lordship, I brought in the issue of roster system only for the simple reason he realized that the office memorandum has been struck down. That is the case with the roster system thing. Now he wants, if he's relying, he can't just.
She's the same petitioner?
Yeah, not the same petitioner.
Oh no.
Not the
In
same
fact,
petitioner, but
in fact,
a
no.
different case.
That's a different case.
In which the office memorandum has
You were a
been
petitioner
struck
in the other case.
down. He was
also.
the petitioner in the case.
I mean, you're a lawyer for the petitioner in the other case.
Yes, and the fallout was that the roster system followed of it. Of the roster system followed from the cover because of the office memorandum. So we also have an issue, Lordship, if he realized that the OM has been struck down in that case and the fallout was the roster system. Now if he's relying on the office memorandum being struck down and he wants to bring that aspect here.
No, but so far as my humble understanding goes, my lord, I think.
Let him finish, yes.
So in that situation, Your Lordship, then court will have to also venture out in looking in the roster. If not, what has fallen from Your Lordship's query? This is absolutely correct, Lordship. The scope is very narrow. As Lordship rightly said, 40, 40, 40, then what happens? With the date of appointment or the fallout will there? Lordship lists the court on that. Whether we should we confine only to Rule 49 interpretation of it, or should we go to the office memorandum? It depends upon the petitioner, Lordship, whether he still relies on the quashing of the office memorandum or not. He has to take the stand very clear.
Just give me the reference of the judgment. Say whether
I think it's a copy, my lord.
49 is not here. Where Rule 49?
Can you have extra copy?
Very interesting. Yes.
Lordship,
Everything was going fine in Lordship till he said the office memorandum has been struck down.
Lordship, if I may, without going into the aspect of the office memorandum and without entering the quicksand of the roster system, my friend is very right when he says the entire matter, if Lordship chooses to examine, entire matter boils down only to the interpretation of the rules, of the governing rules.
Where's Rule 49? It's not here.
There is no Rule 49. The extant rule is 29.
It's 29.
It was wrongly quoted.
Now, my friend's interpretation is wrong only for the reason what he fails to appreciate and what this honorable court will have to appreciate is that there are multiple methods of choosing LDAs under these rules. First method is, first type of LDA, my lord, if Lordship looks at section 3 or rule 3.
We'll go there some other day. I'll just keep these rules with me.
What Lordship, what is fallen from Your Lordship, the query? Instead, Lordship has drawn the parameter. We have to just address their issue.
No, but if they are different modes of recruitment also, then even the same cadre also you can't is a reasonable classification over the feeder of where they come from.
Exactly.
Then there can be reasonable classification
Lordship,
also.
regarding the rules, just to sum up the rules, there are 3 methods of appointment of LDAs.
Okay.
Within each category, the seniority is to be determined by competitive exam. So whoever has done well in the exam, he is senior as far as that list is, that particular category is concerned. Inter se seniority between these categories, for that date of appointment is taken. And that is something, with all due respect, the petitioner is failing to appreciate. He is relying on the fact that date of appointment is relevant. It is relevant only when it is a question of seniority between these 3 categories.
That particular segment.
Absolutely.
Yes. But within the category, it is the competitive exam.
No, the other case was there regarding assistant lecturers, also same thing.
Yes, my
which
lord.
is dealt with regarding the assistant.
I thought I have the judgment, but I'll bring it.
Yes,
there is the
like reasonable classification within the same
yes,
cadre.
Yes, ma'am.
Yes.
Absolutely. And Lordship has dealt with it.
In respect of the methods also, my lord, classification. The rule is very much clear, my lord. I'll just.
Yes.
Lordship, I believe it is Zanera Marak, my lord.
Yes.
Zanera Marak. I believe that is the.
Zarera Marak, Lordship.
No, I've already placed the judgment.
Lordship is in the news.
Which one?
Zarera Marak, that judgment which is relying. Lordship, kindly see the headline of the judgment. The The cutoff date issue has been referred back with the full bench, back to the assembly.
But
With
that
respect to application.
was not in this matter, my lord. Of course, anomalous discrepancy was noted in this matter.
Oh, no, wait, right. We listed when this for further hearing on.
So, Lordship, please.
What is after views? Views just round the corner.
Views tomorrow.
Yes, tomorrow. It's up to your when just you assess the court. This one.
Lordship, a week.
That's up to the court master. He'll give the date. Since
34. 34.
Your Lordship, I bring this matter will be taken up under the next year.
To the other side, Mr. Abraham, yes. On the prayer of your MS Wanyang. E Wanyang. E Wanyang. Yes, matters. Due to absence senior counsel. Yes, also I'm saying.
36.
May I please, Your Lordship?
Now what happened to the appointment?
No one is appointed because Your Lordship interview was conducted not as per
unfit.
First unfit, and secondly Your Lordship interview was conducted without proper consent of proper authorities. Your Lordship.
What is this, Mr.
They have sent me. Yes, Your Lordship.
It is not like that.
Moreover,
see last order you see it was that appointment is being considered subject to the qualification criteria.
Now I am.
Your Lordship, just let me finish.
That is the reason, my lord. That is the reason I have filed and miscase, my lord.
What's the miscase?
Yes, miscase for all for the record, my lord.
Your
because
Lordship,
some of the 10 school, my lord, who I able to get without MTET qualification. Their candidature was approved by the SDSU, Ampati, my lord.
But these are not a part of the writ petition, Your Lordship. These are miscellaneous miscellaneous petition, Your Lordship.
I already mentioned.
Not in the prayer, Your Lordship.
Let's see your instructions.
Yes.
Yes. This case will keep for the time being. We won't pass the orders. Yes,
It is already approved. 10 school. Without MTET. That is the reason I have filed this miscase. All for record.
10 school, is it possible, Your Lordship? Record of 10 schools.
Record is available in the office.
And these are not part of main writ petition.
It is recently after my appointment.
Page 2 onwards, Your Lordship.
one second, page 1, this one, you flagged it.
Page
1 second.
And even in last page number 8, Your Lordship, one notification is also there, 1st July 2020. There also they have mentioned that MTET is mandatory.
What to do, Mr. Sarikal?
No, my lord.
Your fate is sealed.
No, my lord. That is,
No.
that is as per by this thing, whereas there is disparity and violation of Article 14.
Then he can, my learned friend, can come up with a new cause of action, Your Lordship.
No,
Now in
is
that
not
in
the
that
new
case,
form. This is already I have mentioned.
because so much
And there is
irregularity.
2 notification, my lord.
Have you seen these instructions?
Yes, my lord.
You've seen them?
I have given, Your Lordship. See page 8
But
notification.
I know, my lord, because in the entire district, not even a MTET candidate was appointed in SSA or UP.
That is totally wrong. You can't ask for negative equality.
No, that's
just because you know.
No, I know, my lord. Then government also passed one notification. There is lack of MTET candidates, so contractual basis appointment should be.
Contractual is different, but regular appointment is different.
But there must be a candidate for that, my lord. Otherwise, single school teacher, on the request of the managing committee, school is running now.
Single teacher she is.
A single teacher, my lord. No teacher.
What to do?
Your Lordship, because as per this status report, Your Lordship, she is not fit to be appointed as a.
Well, that is the affidavit they have already mentioned.
Already mentioned, but yesterday I received this instruction, Your Lordship.
And that is the reason I filed this miscellaneous case.
This case is just showing that in other schools where they don't have MTET, they've been appointed. Correct?
Yes.
Yes.
Yes, approval letter also I have given. Approval letter, two schools I have able to obtain only. One is 24 January 2022, another is 22nd September 2021, my lord.
But in that even, Your Lordship, without seeking leave of this, Your Lordship, whether my learned friend can come up with this new.
No, that
No,
is.
it's just showing. It's just to bring on record
Yes.
that you know that he wants to show that the petitioner has been discriminated against.
Yes.
That's all.
Yeah,
That the government
that's
is
all.
having different standards for different schools,
Yes.
and for this school they have not. They have a different appointed because they don't have MTET.
Yes.
But then he can also claim negative equality. Maybe that's wrong.
In that
That can be
event,
looked
Your
at in a different proceeding.
I may leave it to the discretion of the Honorable Court, Your Lordship. Because these are my submission apart from.
But afterwards,
After a week, my lord.
and then dispose it off. Okay, I'll keep this record. This MSS Barsaji has produced records and instructions by way of has produced written instructions.
Not even a single school, my lord.
And submitted the same before the court. Stop. Mr. H. Sarika placed that matter be taken for 1 week for hearing. Stop. It is noted for hearing. So it's noted that this case has also been filed. Bring on record the factum of appointment of teacher candidates who do not possess MTET qualification. This is the matter after
2 weeks, Your Lordship.
Very difficult these cases.
Very simple, my lord. To get is the
Simple but difficult to get any relief.
Lordship can creative order can be passed in like
Creative order.